Last few people to come in. All right. How are we feeling about contracts? Basic contract law. That whole concept of when does it become a contract? What is it that takes it? What does it take to become a contract? From last night. What's that depend on? Yeah. There you go. It's not just signing the form, is it? It's not just signing that offer. That's not enough. And so the test question will probably be something where it spells out a nice little story. So-and-so agent, so-and-so client, buyer, passed the offer over to the seller side. Listing agent sent it up to the seller. They signed it, maybe or no changes made, and then told their listing agent. And the listing agent then, that was at 6 p.m. And then at 7 p.m., the listing agent told the buyer's agent. And then at 7:30, the buyer agent told their buyer. And on the next day, the contract was actually delivered the next morning. So at what point did it become under contract? And a lot of people say the next day when that paperwork was delivered, but that's not it. Paperwork doesn't make it. It's just the communication. Yes, it needs to be followed up with because you do need to have it in writing, but that communication is the main point. What about the money? We talked about what is going to accompany a basic offer to purchase, and that included the offer to purchase paperwork. I think Victor said some addenda along with that. And then we talked about due diligence check and earnest money check and maybe even a pre-approval letter just to make it nice and strong. Or if it's cash, a proof of funds letter from the bank showing that they really do have the money. But when do they have to provide those checks? When do those checks due? I'm looking up that form to show you some stuff. But while I'm looking, there we go. Let's talk about that. The due diligence check. Tell me. Go ahead. What do you mean? Yeah, it's live. You're welcome. When is that due diligence money due? Let's look at that offer to purchase. Don't forget, you have this in your Google Drive, and it would be good to look at it, read through it, to get familiar, because you can get a lot of easy points just by knowing the basics of the offer to purchase. 1 second, let me make sure I just put that here in the chat for you. There we go. Okay. So if we look on the front page of this offer to purchase and scroll down a little bit to where it talks about the due diligence fee right in the middle, when is that due diligence fee due? Tell me. Yeah, that magical E word called effective date. The effective date, what do we mean by the effective date? What's that referring to? Yes, exactly. When it's signed now we all just talked about that it also has to be communicated. So ideally, it's going to be the same date it is communicated. But there is a chance it could get signed and then not communicated until the next day. So good practice, best practice, let's make sure that we match those dates up. But officially in court, having to prove things, what is the effective date? The last date that a signature or initial shows up on the actual contract. And so that's when this due diligence money is due. So what does that mean? Let's think about that. We just showed 17 houses, all of us. We're just one big group. We're one big real estate team. We all got on our little real estate school bus that we drive around showing property to people. Super convenient, right? And we get on that bus. We show them 17 properties tonight. We all roll up to the office right about now, and we sit down and explain to the client how the offer works. One of us, maybe we use our resources, and one of us goes ahead and does some research on the market analysis to see what it's even worth, to see what it should sell for is a better way for me to say that. Because just because it's listed at $345 doesn't mean it's actually worth $345. We need to find out what it will sell for, and if they're just crazy, that seller, with a ridiculous list price. So that's one of the tasks we need to do. We figure out what range it should sell for, and we talk to our client. We figure out, what do you want to offer? How bad do you want it? Another step would be on the way back to the office, maybe we call the listing agent and say, what can you tell me that the seller wants? What could we do to make this offer attractive to the seller? And then you be quiet and let them fill the space, right? People can't resist filling up silent space, and sometimes they tell us more than they should. It's just nature, just human nature, just negotiating 101. And they might say, well, gosh, I'm so glad we've had lots of showings, but no offers. And this seller just, they just got notified from their company. All the timelines moved up. They really need to get out of there. And you're just scribbling down notes because you're going to report all of this back to your buyer, right? Anyway, we figure out what we're going to offer and we put it all down. We get all those things together we talked about and we submit the offer to the listing agent. Maybe it takes us about an hour or so, around 6:45 or so tonight. We send over that offer. And of course, we're going to do the smart thing and not just email it to them, but call them, leave a voicemail if they don't answer, text them, email them a second time and say, look, there is an offer waiting for you. Please be aware of this, right? We don't want to ever go back and say, well, we emailed it. I don't know why you didn't notice it. Let's do all we can, come at them from multiple angles to make sure that they know there is an offer. So they look at it. No other offers have come in, maybe. Maybe we're the only one. And they talk to the seller tonight too. Maybe by 10:30 tonight, we have a deal. Seller has agreed. They've signed it. They've told their agent. Their agent has told us. And we're buyer's agents, so that's good enough. We go ahead and tell our buyer, but we are under contract. This, today, July 27th, is the effective date. And so part of the negotiating was a $10,000 check for due diligence fee from our buyer. What do we need to do now? What do we do at this point? Any guesses? No reason you should know this. We need to get a check from our buyer, don't we? And we need to deliver that check to the seller. The seller ideally needs to get that check in hand. But wait, it's 10:45 at night, p.m. Officially, they need to have that check within an hour and 15 minutes. Wait a minute. Are we getting out of our pajamas, putting our street clothes back on, going back out into the wild? Well, it depends. What commonly happens out in real life is the agents will say, look, it's 11 o'clock at night. Let's just get together tomorrow and I'll get you those checks. Is that okay with you? And most of the time it is. But for the purposes of this class and this test, what if in real life, what if the seller was particularly worried about it? Maybe they had a situation that went wrong before this, and they're just really nervous about not having that money in hand and not allowing any more showings without the due diligence money in hand yet. They could force it. They could say, look, if you don't get me that due diligence money by tonight, in the next hour and 15 minutes of effective date that we have left, then I'm going to give you written notice that you have a 24-hour deadline to bring me that check. And if you don't, I, the seller, can back out of this with no penalty. Now, you might be thinking, well, we were going to get it to you tomorrow anyway. Why are you being such a jerk? But that's just the rules. That's how that works. If you don't get that due diligence money to them, let's see if I can find it. They can tell you, we want it within 24 hours. There it is. It's right there. First paragraph of the second page. Buyer fails to deliver due diligence or initial earnest money by their due dates, or if those checks bounce, the buyer has one banking day after written notice to deliver real money. No personal checks this time. You ruined that. You messed that up for yourself, buyer. It's going to have to be either cash, a bank check, or a wire within one banking day. If they don't deliver those funds, the seller can choose to terminate this contract by just giving written notice and be entitled to recover that. Still, they got to get the due diligence fee and any earnest money that might be due and payable. In addition, if this turns into a real ugly situation, they go to court over it, the seller could be entitled to court costs, attorney fees. Does this happen a lot? I don't think so. I think what usually happens is what I mentioned. It's 11 o'clock. Let's just get together tomorrow. It's only going to matter if it matters to the seller. But you're going to need to know it for the test possibly. What could happen if the due diligence money is not turned in by the effective date? The seller could give basically a demand to receive it within a banking day. Well, the way that scenario is probably not as common, but what might be more common is it's been a couple of days and the agents were maybe a little bit slack, or maybe just for some reason the agents haven't gotten together, haven't gotten the money from the buyer, and maybe after 2 or 3 days the seller's like, wait a minute, what happened to this due diligence check I'm supposed to be getting? Why don't I have it yet? At that point, if that buyer were to choose to walk away and the seller had gone ahead and allowed their agent to take it off the market, which it needs to be taken off the market, it is officially under contract, then the seller has lost and wasted 2 or 3 days off the market. And then the buyer walks away and decides not to buy it. What does the seller have as leverage against that buyer walking away? Typically due diligence money, but they don't this time because it didn't get turned in. You following me? This is real world. This can get ugly. Sometimes agents get lazy and say, let me just drop it in the mail to you. And it doesn't count, right? That money in hand of the seller the mailbox rule doesn't apply to the money. So that's not good enough. It's got to be turned in by effective date unless everybody's cool with the later date. But it matters when it matters. It doesn't matter unless it matters, all right? So if people get up in arms about it, we have a problem. And that problem probably is going to rest on our shoulders. Because I think with so many offers flying around these last few years, agents were getting lazy and kind of just slack about these sorts of details. So here's the testable question. The money, the due diligence check has not been delivered to the seller, and it's been 3 days since the contract went under contract. The actual property went under contract. Are we under contract if the money has not been delivered? Does the status of the contract matter and depend on the money itself at all? Let's recap. They sign the offer tonight. Becomes a contract tonight. The agents get a little slack and say, you know what, I'm busy tomorrow. You're busy tomorrow. Plus, tomorrow's Friday. Gosh, it's pretty much the weekend already. Let's just meet on Sunday and I'll get you that due diligence check on Sunday. Terrible idea. Are they beyond the due date? Yes. This is the due date. Today's the effective date, but they're talking about waiting until Sunday to get it into the seller's hands. Well, Sunday rolls around and something happens and the buyer says, you know what, forget it. I just don't want to buy it anymore. What do you tell your seller? Hey, seller, the buyer's backing out. They don't want to buy it. And the seller says, Well, I don't care. At least we have the due diligence money, right? You do have that, right? I assume since I don't have it, you have it, Mr. Agent, right? And you have to say, well, actually, see, here's the thing. I don't. Should have had it in the last couple of days ago, but I still don't have it. And do we think a seller might be a little frustrated with us at this point? There's the problem. They have no leverage. And they lost. Did you have to put it in the system in the MLS as under contract? Yes, because it was under contract. The money doesn't make a difference to the contract status. You with me? Write that one down. The fact that it's under contract has nothing to do with the delivery of the money. It's still under contract. It's just that your client, your seller client, doesn't have any leverage now, and we have other problems now. For one thing, you are disciplinable, right? They might complain that you didn't do all you could to get that money into their hands, and now they've lost a couple of days being on the market for nothing. Which phrase? The one I just said? Let's see. It doesn't depend on the money. The status of the under contract has nothing to do with the money being delivered. It's still under contract even though the money hasn't been delivered. Whether it's the due diligence money in the very beginning, because that's the first money that probably is going to get delivered. Let's take a look. We've got a couple of things here. Due diligence money or fee due by the effective date. What's some other money? We talked about earnest money. We've got two different entries for earnest money that we could possibly use. We've got one called initial earnest money, and then we've got one called additional earnest money. Let's look at the differences. Now, if you had to guess, you'd probably assume initial earnest money means earnest money that you give in the beginning, and then additional means if you're going to give them more later, that's what that is talking about. But it's not as simple as that. It doesn't even, you don't have to leave either one of them, for one thing, right? All of three of these things are optional, as long as the seller's okay with it, but they're not right now, right? But even down to just the earnest money itself, there we go. Initial says this: if we give them initial earnest money, when is it due? Within 5 days of the effective date. But what if we give additional earnest money? When is that due? No later than 5 p.m. on fill in the blank date, whenever your client wants. Whenever the clients agree that the additional earnest money will be submitted is when it's due. So here's the thing. We don't even have to give them earnest money in the beginning. We don't have to do this within 5 days of effective date if we call it additional earnest money instead. Why would we want to set a specific date other than in the very beginning within the first 5 days? Yeah, sorry, Misha. It would certainly depend on what the seller and the buyer are both okay with. Yeah, but the money being delivered, if the seller's cool with it being delivered, the due diligence, then probably a non-issue. And frankly, it is usually a non-issue. But for the test for this course, you have to know what could happen in the worst case scenario. So here's the thing. We have a due diligence deadline that we have established in the offer. And it's down here, bottom of the second page, due diligence period, beginning on the effective date, extending through 5 p.m., fill in the blank of a date. That's the time period that buyer has to back out for any reason or no reason. It's the time period that they're going to do their inspections, anything else, anything that they need to discover that could cause them to choose to change their mind. What if the inspections happen? Let me flip over to something else here. What if the inspections happen? We've got our under contract date. We've got our whole duration of that all the way to a closing day. Then we've got our due diligence deadline. What if all these inspections and all these various things take place and the buyer chooses to back out like a day before the due diligence period? What's that buyer supposed to get if they back out within the due diligence period? They lost the due diligence money. They gave that in the beginning. They don't get that back. But now this earnest money should come back to them because they did it in the time period that they had. It was negotiated that they had. But what if the seller doesn't go along with this plan? Because here's how this works. I'm the buyer agent. I call the listing agent and I say, look, the buyer changed their mind. They don't want to buy this house. Just too many things wrong with it. No offense. Even if your seller would have fixed stuff, they just don't want to move forward. And the listing agent tells the seller, and the seller says, what? I've already had some of that stuff fixed. We were negotiating repairs, but I saw the list. You sent over the repair request and the inspection report, and I went ahead and spent money, and I've already gone ahead and picked a house I want to go buy. And that's crazy. It's only one more day to due diligence, and I'm mad at this buyer. I will not sign the termination with release of earnest money. I won't release the earnest money. Even though in the contract it says that they should and that the buyer is entitled to it, ultimately the seller would have to sign a release of earnest money. And we, the brokers, can't do anything about that. We are not the enforcers. We're just the facilitators. And we can't make that seller sign this, even though it's in writing that they should. Who's going to have to make them? Nobody today. This ain't getting settled today, is it? Right, exactly. It's attorneys in court, a judge, court process, judge. So the buyer and the seller are mad at each other. We have a dead deal. Buyer's not forced to buy it. Seller's not releasing the earnest money. So basically, let's make this even more of a pathetic situation. Not only is the seller kind of misbehaving, but it just so happens this buyer is getting an FHA loan because they need a low down payment. We'll talk about that later. They don't have much money to work with. This $10,000 due diligence, or sorry, it was $10,000 due diligence. Let's say it's another $10,000 earnest money. Now they're out $20,000. Can they maybe jump right back on the horse and look for houses again? Maybe not. So what has just happened? The seller is holding their earnest money hostage, aren't they? That's what I call it. Seller's refusing to sign the release. And there's nothing anybody can do about it except just go through that very slow court process. How could we keep this from happening, though? What if there was a way that we could keep the seller from having control over this earnest money? Well, we can't keep them from having that control over the earnest money, but we can keep them from being any earnest money in the mix yet. So what if instead of that earnest money already being turned in back here within the first 5 days and therefore sitting in a trust account, that now the seller can choose not to sign a release for it to be released? What if instead of that, we knew our contract like the back of our hand, and instead of putting in initial earnest money due within 5 days, we said, to heck with that. I'm a good buyer agent looking out for my buyer. I'm going to do additional earnest money only, and we're going to say the due date is the day of the due diligence deadline. I'm seeing nods. So now if that buyer chooses to back out within the due diligence period and the seller says, I'm not signing the release, we say, there's nothing to be released. Na boo boo, right? There's nothing. We knew that you might be this way, so we didn't allow it to be turned in yet, and you agreed. Back when you signed the contract, you agreed to allow additional earnest money only due on the same date as maybe day before, maybe day of the due diligence. And people still aren't really aware of this little loophole. I run into agents all the time that don't understand how this thing works. And what are we doing? We're a buyer agent looking out for our buyer, making sure they have full control over their money until the last possible minute. And nobody like a seller can hold power over that and refuse to release it. See why that's important? So that's what the two kinds of earnest money are about. All they're about is when are they due? Is it within 5 days of effective date, or is it the date of your choice? Notice a couple other things. If we go with initial earnest money, you have the luxury of writing it as a personal check. But if we go with additional earnest money where you pick your own date, there is no personal check option. It's got to be cash or a bank or certified check. It's got to be ready funds. That's what those are called. Ready funds. No 10 days waiting for a check to clear kind of a deal. Right. Oh, and then notice it's the other place on this contract that says time is of the essence. There's only two places where it says time is of the essence. Right there, if we choose to use additional earnest money, and then also for the due diligence period, that date is the time is of the essence date. Yeah, exactly. Joseph says, how would you do this? You would just leave this part blank. You would just leave the initial earnest money part alone, put in 0, and then just put the money all on this line. And that's it. Even attorneys don't pay attention to this. I catch that all the time. The closing attorney mistakenly, because if you go to like the last page of this contract, it's got the signing page, the receipt page, the receipt of those monies. And this is where people sign acknowledging that you've turned in the money properly, like the due diligence fee. If we hand the due diligence fee to the listing agent for them to deliver to the seller, then we need to get them to sign off saying that we gave it to them. We are the buyer agent, so that we have proof that they have it now. And then once they have delivered it to the seller like they should, the seller needs to sign saying, yep, they gave it to me. And the same thing for earnest money, except we don't give that to the seller. Whoever's holding it, whichever firm or if it's a real estate attorney, they need to sign. But notice there's two different, it's not both of these that need to be done necessarily. It's whichever one it is. Is it initial earnest money or additional? And it could be both. I say all that to say that it still could be both. Maybe for some reason initially we do just go with initial earnest money, and then part of the repair request or maybe there's an extension request to close later, and maybe the parties say, well, will you give me more earnest money to show me that you're serious, but you still want to buy it, but you just need more time. So you could use them both if you needed to. In those cases where we're going past a closing date, or if maybe we're going past the due diligence deadline because they couldn't get all their stuff done in time, they're probably going to want more due diligence money because it's non-refundable. So in order to go past this deadline, the seller's going to have to give permission. And they're probably going to say, sure, I'll let you do that as long as you give me more of this. I want more due diligence money. I just ran into that with my house. They're going 30 days, maybe 60 days past the original, which would be tomorrow. And since they need to go beyond that, they're giving us some more non-refundable due diligence money that we go ahead and can have now. So does that make sense? The money has nothing to do with whether it's under contract. The people are going to be mad about the money, but that's not for us as brokers to work out. We're not enforcers. They're going to have to settle that up through the court system. And don't let a test question give you details on money, whether it's been received and blah, 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 and get tricked by that. Just know, okay, the money is a separate situation. When was it communicated that it was signed and accepted? That's the date that matters. Let's see. What do we leave off with? I think we went over this one, but let me do it again. Yeah, we went a little past this. Buyer makes an offer for $150,000. The seller counters at $153,000. The buyer says no, decides to keep looking. The seller then realizes they should have taken it, and they try. And they say, wait, I'll go back to the $150,000. Does the buyer have to honor the original offer of 150 at this point. It's dead in the water, right? That seller killed it when they countered. The buyer could resurrect it, say, yeah, okay, we'll do it, but it's not automatic. Good job. Statute of frauds is important to keep separate. There's two things that we run into. Let me point out. There's the statute of frauds, which says must be in writing to be enforceable. And then there's the Connor Act, which says it must be recorded, the document, to protect against third-party claims. Meaning people coming along and saying, hey, I own this too. So know the difference between the statute of frauds and the Connor Act. Know the difference between those. That's important. Statute of frauds, writing to be enforceable. That applies to real estate contracts, leases longer than 3 years, not 3 years or less, but longer than 3, and option contracts. All of those fall under this, must be in writing to be enforceable. And then the UETA is what allows us to have electronic signatures, and that's good enough. That's perfectly legal signature, creates a legal contract. Talks about how contracts could terminate, full performance, impossibility of performance, operation of law, but not death of the seller, because the estate and the heirs could still be required to fulfill that. We left off here. Anybody check out Pace Morby's videos? He's the wholesaler guy selling courses these days. He's actually got a program where he's, I think, trying to get investors to find deals and pass them off to him, assign them to him. Yeah, popular on TikTok. It's going to be a bigger and bigger thing, because subject to means we can enjoy a much lower interest rate than what the market will provide right now. If the rates are 6-7+%, it's a lot of opportunity. I forgot what the stat is. It's like 70 or 80% of loans are at 3% interest rate or less, something huge like that. So there's a lot of potential. But it's got to be done correctly. Don't be that kind of investor that's just trying to sign up a desperate seller to a contract just so that you can sell it to or assign it to another buyer if you couldn't actually perform on it yourself. That's what the commission says. You better be able to perform on it yourself. Can you get a loan? Do you really have the money, or were you just trying to purely assign it from the get-go? Substituting parties. And here's the thing. Is a contract assignable? Can a contract be assigned? It depends on what the contract says. And in our standard one that we just looked at just now, the standard 2T, the wording is, yes, it's assignable as long as the seller gives permission and is aware. Seller must agree to it. But you could certainly make a contract yourself if you're the buyer, not as a broker, but if you're a buyer yourself, investor buyer, you could have an attorney draw up a contract. Heck, you could do your research and write one yourself, because the parties to the transaction are allowed to make their own paperwork, addenda, amendments, contracts. And so you could have one that says, yes, this is assignable, and you better believe it. Pace Morby and those other guys that do those things, they have a special made contract that has that permission in it. And it's probably very fine print, innocuous, hard to really notice. And people are like, that's the thing. How above board are you? Are you doing it and trying not to let people realize that it's assignable? That was the original problem, where an investor would hope the seller didn't even notice, and the investor never even planned on buying it, and so they assigned it. And if that person that they assigned it to ended up breaching, is the seller in trouble or not? Is the seller messed up? And so here it is. Buyer number one that initially found the deal assigns the contract to buyer number two, or the assignee. The first buyer still remains secondarily liable for performance. So if that one that they assigned it to doesn't go through with it, then they're responsible in a secondary position themselves legally. So you transfer your rights and duties with the assignment to a new person, but not the liabilities of the first party. We saw the two places on the contract, standard 2T contract, that say time is of the essence. And what that means is drop dead date no later than the time and date mentioned for this particular issue. In this case, it was the receipt of the additional earnest money no later than 5 p.m. on fill in the blank date, and the expiration of the due diligence period no later than 5 p.m. on whatever date's put in there. So that's time is of the essence. That just means it's a hard date that cannot be extended without permission. If you'll notice, we look a little further, here's the settlement date. Some people would call that the closing date, but we know better. We know that settlement is when signing happens and closing is when recording happens. It's not closed until the deed is recorded. But the settlement date is when everybody's signing things. And you notice something's missing here. There's no time is of the essence on the settlement date. It's because it quite frequently gets delayed. I'm not going to say always or most of the time, but it's not unheard of that any number of things could cause that settlement to be delayed. So putting time is of the essence isn't something we do. In fact, if it is delayed, here's the other thing. Anybody happen to know what happens if the settlement gets delayed? How much longer can we go? What's the built-in amount of buffer or cushion, number of days that we can delay the settlement if maybe the lender is slow or repairs didn't get negotiated or repairs didn't get made? How many days can it be delayed without either party having the right to try to penalize the other side or charge a daily? There we go. Kirsty says 7 days. If we look at item 12, delay in settlement, if the delaying party fails to complete it within 7 days of the original settlement date, then the delaying party is in breach, and the non-delaying party can terminate and enforce any remedies available to them. What remedies are available to a seller if the buyer breaches? If it's the buyer that causes this delay, what's the seller have available to them? The liquidated damages. We'll see that in the next chapter. And we made a quick reference to that last night. Earnest money and due diligence money. Those are what's called liquidated damages. What if it's the seller that delays? Somehow the seller's the delaying party. What remedies are available to the buyer if the seller's the one who's breaching the contract? Something called specific performance. You can sue them for specific performance. And we'll cover that tonight too. So hard dates is what we're talking about with time is of the essence. If it doesn't say specifically time is of the essence, they're just target dates. We're shooting for it, but that's it. A novation, that's another $5 word to know, substituting a new contract. You're avoiding the existing terms without breaching the contract. You're maybe having new parties added or maybe just the same parties. You're swapping out a new one for the old one. And it's supported by consideration. It conforms to all the same essential elements. Novation is just think new contract. So what if when the parties are talking in the beginning, the offer's made and the parties are talking to their agents and the agents are calling each other and saying, well, they'll do this, but not that. And maybe some of that talk is about the washing machine, the dryer, the refrigerator, whether that's included. Well, at this price, I'll include it, but at this price, I won't. And can be a lot of back and forth chatter, whether through text, email, or on the phone. And you got to keep careful notes and keep track of what do they want to do now. And frankly, some of the back and forth can go 5 or 10 counters. back and forth, and you're like, oh my gosh, we're haggling over like a dining room table. That's when it gets real good. You're like, I'm not a yard salesperson. I am trying to sell houses. Why are we talking about the table? But it can really get down to that, and you're like, oh my gosh. So the interpretation of the contracts, you got to be careful what that contract ends up looking like. Did you, every time you made a change, did you cross something out and get your client to initial and date the new item? Because real quickly, it could become illegible. I mean, look at that thing. It's pretty hard to read it as it is. It's pretty small print. But if we get down here to fixtures, these lines, and we've got things written in and crossed out and dated, and then maybe there's a thing about the warranty. If that gets kind of in the way, there it is. Whether the seller's willing to pay for one or not. Originally we checked no, but then we checked that the buyer could choose one because the buyer agreed to pay a little more for the house, but only if they provided a warranty, because that heating and air system is old and the water heater's old. How many initials and changes and dates can we fit into the margins? It gets ugly. It can get in the way. So the main recommendation from the commission is, when you figure it all out and finally get to the bottom line and everybody has agreed to the final version, don't use the same one you've been marking up this whole time. Write it up nice and clean and fresh and legible, easy to read. Don't use the one with all the changes in it. Use the one with the final terms in it. So that's kind of what this is talking about. How do we interpret a contract? The preliminary negotiations don't matter. All that back and forth talk on the phone, irrelevant if it doesn't get into the contract that's finalized. It must be in the contract in order to be enforceable. Another side example of that we've already talked about is, what if the MLS in the advertising says washer, dryer, refrigerator included with this house, but the agents forget to put it in the contract? Guess what's not legally included in the house now? That seller could take them, even though the buyer wanted them. But if it didn't make it into the contract, there's nothing enforceable, because preliminary negotiations are not admissible if not written into the contract. They like to test you on that. They'll paint a whole big story, and then you need to watch for, did they say that it got put into the contract? Look out for it. So the written contract is what rules. It must be reasonable to assume that this is what was meant. If there's like some ambiguity, it's unclear. It needs to be, the contract is interpreted as a whole. You can't just focus in on one little provision. You've got to look at it as the whole big picture. And the words used, if things are being written, addenda, amendments are being put in, any words are interpreted in their ordinary meaning. You can't play some fancy acrobatics in attorney language, like what's the definition of is or there or something like that. Anything that is ambiguous is going to be judged against the one who wrote that language. That's how serious they take it. Look, don't try to fool somebody with unclear language. You're going to take the hit for it. If you're the one who wrote the unclear language, you're going to take the hit. So the parole evidence rule, another $5 term, what we verbally agreed to doesn't matter at all. Must put all the terms in the contract. But they said this, irrelevant. What was in the contract? Let's talk about breach. Breach just means the terms and the promises weren't honored. The parties in good faith said they would do things and they didn't do those things. So they breached the contract, and it's different penalties for the seller than for the buyer. Those aren't the same penalties for each. When you're going to court over breach, whether it's real estate or anything else, there's a couple of terms that you run into. Compensatory damages means we're making the party whole again. They were harmed financially, so how much money will it take to make them whole, to restore them? Consequential damages means they've lost out on profits, and we need to make that up to them too. So they might have compensatory damages in the amount of this much. They might have consequential damages in the amount of this much for lost profits. Another option could be, let's just bring everybody back to their starting point, called rescission. Both parties return to their original positions. That might be another possible outcome in a court situation. Specifically to real estate, let's talk about the damages available, the consequences available. And so I mentioned it a minute ago. If it is the seller, let's just say you're contracted to buy somebody's property and you do all your inspections. Let's look at it. You say, well, hey seller, pick me, please pick my offer. So there's some $10,000 due diligence money for you. I'll give you another $5,000 earnest money. And let me go ahead and have inspections, and I have to get the general inspection. I'm choosing to get the general inspection, and that's like $600. I'm going to get a mold specialist because the general inspector showed that there might be some fungal growth going on, and there's another $800. Need to get a termite, and that's like another $100. Radon, that's probably $150 add-on. Let's see what else. Maybe one of the things that the inspector reveals is that there's a structural problem. Thank you. That's a good one, Victor. Let's do septic. Let's throw that in there. We'll call that another $150. A structural engineer's letter is needed to figure out what's wrong with the foundation and what needs to be done to fix it. And so you might say, well, let's just let the seller do that. Well, the problem is, if the seller hires them, hopefully they're going to still report the same info, but I'd rather get advice from the person I hire. So might be a good idea to get your own structural engineer to go out there and look at it. So the buyer does that and they spend money on that. Survey needs to be done. The appraisal, they had to spend money on that in the beginning. That might have been another $500-600. Survey, if it's a big enough property, it could be close to $1,000 or more. Let's just call it $700. We got a lot of stuff here, and we still don't have a closing. And now, let's say we are 3 days from closing, and the seller says, you know what? This is just too nostalgic a property. All my kids grew up here. We just found out we're getting grandkids. This will be a great property, good house to keep for the memories, so we don't want to sell anymore. How do we feel about this as a buyer? Is this seller, do they have the option to sell or not sell like the buyer has the option to buy or not buy? It's not the same, is it? The buyer's freedoms to choose to move forward with the purchase aren't quite the same as the seller. In other words, I've had occasionally a seller who doesn't take it seriously, and they say, well, let's just go ahead and accept it now, and if we decide to change our mind later, we'll just back out. And I'm like, no. You need to figure this out now, because the consequences to you, seller, for backing out are dire. They are severe. So here we are. Do you think the buyer is going to want all of these things reimbursed to them? Well, sure. Do you think the law supports that? Yes, it does. So not only are they going to sue or have the ability to sue for specific performance, meaning this is the only property like itself. It's unique. That's one of the characteristics of real estate. Unique property is unique. So I'm going to sue you because I can't replicate this property anywhere else. So I'm going to sue you for this, and I'm going to sue you for the money I had to spend in the good faith effort to buy it to begin with. And what is this? We're at 15,000. That's another 16, 17, it's like 18, close to $20,000 on top of sued for specific performance. So it's a big deal. Those are the penalties to the seller for breaching, getting sued for specific performance and having to reimburse for all the potential money that buyer has paid out in the process of trying to buy it. So there's the top one. Don't let the test question mess you up. What is available as a remedy to the buyer if the seller breaches? specific performance and reimbursement of all the other fees and costs. But that's not the same remedy available to the seller if the buyer breaches. They like to flip-flop those on you. What's available to the seller if the buyer breaches? Well, it's already in there. We've talked about it. It's two things. It's earnest money and due diligence money. That's it. So here's how it works. We're under contract. We put up the due diligence money. We've got our little timeline. Here's our closing date. Here's our due diligence deadline. And then once we get into this realm, now the earnest money is also in jeopardy, right? The seller is entitled to that if the buyer walks out at this point in time. So if we're the listing agent, when we get these 45 offers at the same time, we're going to say, hey, seller, you've got a couple offers. Let's just say there's two. Offer one and offer number two. Offer number one is giving you due diligence money in the amount of $10,000, and offer two is giving you due diligence money in the amount of $5,000. Offer one is giving you earnest money in the amount of $5,000, and offer two is giving you earnest money in the amount of $5,000. If the price is the same and everything else is the same, which one? Well, let me make a difference here. Let me change that. That doesn't help. Let's make it 1,000. That's what I meant to do. 10,000 for due diligence money and offer one, 1,000 for earnest money later, right? So we've set up that maybe the day of due diligence is when the earnest money is due. That's just the way that is. Which of these is the seller going to like more if the buyer backs out the day before closing? In the beginning, that seller might gravitate toward this one all day long because they're getting more upfront non-refundable money. But it's our job to remind that seller, hey, seller, I know this is attractive, but don't forget, let me paint a scenario for you. What if we go all the way up to the day before closing and the buyer has done all this stuff to get ready to buy it, but you've also done a lot of stuff to get ready to sell it. You've emptied your house. You've gone ahead and loaded up a moving truck. You've got another house that you're going to close an hour after you close on selling this one, using these proceeds to buy that one. So you got that on the line. What if this were to fall apart and the buyer were to breach and no longer buy it? Now you're not going to be able to buy the one you want to buy. You're going to have to pull all that stuff off the moving truck and pay for two moves now, right? Instead of just the one, and it was the last minute. In other words, are you going to, at that point, if that were to happen, wish you had a little more money than another $1,000? Because maybe you spent that entire 10 as you were entitled to, because it is non-refundable. Wouldn't it be nice if you at least had more than 1,000 in that scenario? So that's why it matters. That's why it's kind of could be foolish to front load, right? Front load due diligence money at the expense of earnest money, as many people do. Because a lot of times people will say, let me offer them this. And then the seller comes back, well, no, I don't want this. I want this because I want the non-refundable money now. But as a listing agent, let's remind them, what would happen if they breached and you've already committed and you got money on the line yourself? The only thing you have left is whatever earnest money is coming your way from this breach happening. That's when that matters. So, testable, what's available? You tell me in the chat. What are the remedies available to the buyer if the seller breaches? What happens if the seller breaches? What can the buyer do? Yeah, that's right. Sue the seller for specific performance and also sue to recover all the money they've spent. Yep. What about if the buyer breaches? What's available to the seller? Yep, that earnest money and that due diligence money. They better be happy with it because that's all they're getting according to the standard contract offer to purchase 2T. All right, let's see. Almost done with chapter 9. If the buyer breaches the contract, that's what we just did. We as brokers can't give legal advice. I think we might have hit that point a couple times by now. We can't draft these legal documents. Draft doesn't mean fill in the blanks. We're allowed to fill in the blanks. Draft means write it from scratch. And so something that happens occasionally is you'll see an offer come in, and down here where all those addenda are listed, wherever that is, I lost it. Oh. There it is. They check a box here and say, see addendum C or A or Z. And you look at it and it's clearly written from scratch. The question is, who wrote it? Did the broker write it? And that would not be okay. Or did the parties to the transaction write it? That's legal, but still probably foolish. They probably should have had an attorney draft it. Because if you see the word in the test, draft legal language, write legal language, it's not something we're allowed to do. We can't draft legal language. We can't write legal language. We can just fill in the blanks. And those forms that we're allowed to use can only be used by who? Who's allowed to use those NC Realtor and NC Bar forms? Can an unrepresented seller selling to an unrepresented buyer use those forms? We'll probably cover that more in the next chapter, but no, only people who belong to those associations. So you could give them a sample form so they could see what a real contract looks like. If you're trying to kind of get on the good side of a for sale by owner and provide them with maybe the disclosures, you can do that they can use, but you can't give them a contract they can use. You could give them a contract that has the word sample across it that looks like that. You can see that grayed out word sample, but they can't use it. So if the parties want to add to the terms of an offer to purchase, they'll use an additional provisions addendum, true or false. Is this an addendum? I mean, is this an offer or a contract? It's an offer. So they need to add to the offer. They're using addendum to add things. And that's just one of several types of addenda they could use. If they want to change the terms of a contract, they would use a due diligence addendum, true or false. Right. Because they're changing a contract, they're not going to use an addendum to change a contract. Did I say false on this one? I meant true. If they want to add to the terms of an offer, they would use an addendum for that. I'm not sure what I said there. That one was true. This one was false. What's also true is that we have a break. And when we come back from that break, we'll talk about chapter 10. See you back here in 10 minutes. Welcome back. Let's talk about chapter 10. 10 is a deep one. It's about 7 hours worth. It's going to get into the weeds about contracts and procedures. There we go. Yep. Sales contracts and practices, unit 10, same as syllabus section 10. So let's, as a little reminder, hopefully you're doing this. Don't forget your buddy, the syllabus. It's your best friend. So we are down to, let's see how far down we are. That's 8. Just did a little 1.5 hours, chapter 9, which is that one. So I would say go back through it on the one that you printed out and write definitions from memory and then go see how good you are. All you got to do is look them up in the glossary in the back of the book and you can get them real quick. You could also find them within the chapter too, as well, And then work your way on down through. Read this first as a reminder. Look up these things based on what we talked about in class, what you see in the chapter that you read, and write them and reference what pages you can find them. It's pretend you've been hired to help somebody create review material, right? So in another 5 weeks or so, you have something nice and easy to look back at, so you're not having to do it all from scratch. And by the way, this thing about the statute of frauds, hot linked to General Statute 22-2. You can just click on that and go see it right here. There. All contracts of land, any interest concerning them, under subsurface rights, whatever they are. So don't forget that. Don't forget what you can learn by clicking on those blue links. And that brings us to chapter 10. 7.5 hours. The first little bit's going to be level 2. Here's some reference to general statutes, license law, and commission rule. We can't draft contracts. We just said at the end of chapter 9, we're saying it again at the top of chapter 10. Do you think they care about that? So look out for those types of things on the questions, on the test. It's not a bad idea to spend some time just kind of as a review, looking through this thing and think about what you know, maybe even in the beginning. So some of these sections in the syllabus give you more to go on than others. They're not always just the words, like just the definitions. So we're going to first talk about the importance of a sales contract, the parameters of a legally binding agreement between buyer and seller, how we do have standardized forms available to us. And those are intended to create some uniformity. They're written with neither the buyer nor the seller in mind as a preference. They're more fairly and balanced, they're more balanced, right? Fairly written to both sides. And they are written and provided to reduce our need and temptation to write new, fresh language from scratch and break the law. Because doing so, drafting is unauthorized practice of law. And I would cross-check these things. Click on those links, go see where this shows up. We're allowed to fill in the blanks of pre-printed forms, but anything unique needs to be drafted by an attorney. Now, legally, again, it could be written by the parties to the transaction. It's not illegal for that to happen. It's just that if you're not an attorney, you might overlook something that needs to be included. Sometimes it's not as simple as just a sentence or two. What does that sentence bring into play? Well, that's what attorneys are for. Well, then you need to have this in place, that in place, right? So it's important to cover all the bases. We as brokers are expected to know when we need to use which forms. Which of the old car fiduciary duties does that fall under? What is it that says that we need to know what we're doing? Which of those duties is it? Obedience, loyalty, disclosure, confidentiality, accounting, and reasonable skill and care. Yeah, Deborah says the last R, reasonable skill and care, including honesty and fairness. But we need to know the situation and what form is needed and when the client should be referred to an attorney to draft something up custom. So tell me that too. What sorts of situations require the contract to be written by an attorney? There is no standard fill in the blank version of some things that we might need a contract for. What sorts of things are those? When do we need an attorney to draft it? I'll give you a multiple choice. We have a buyer client that wants to buy a house that's listed on the MLS. That's choice A. Do we need an attorney to do that? Or B, we have a buyer client who wants to buy a house from a seller and also ask the seller to finance the purchase, seller financing. A or B, which one do we need an attorney to draw up? There is no seller financing available to us. That's a standard form. We've got to have that written, made from scratch, don't we? So any sort of seller financing, because now it's more than just a contract. It's now it's a financial instrument. It's something signifying interest rate and number of payments and amount borrowed. That's out of our league. What if we have a client that wants to rent for a year and then let part of their rent every month count toward their down payment and purchase it at the end of a year, a lease with option to buy? Do we have lease forms available to us? And do we have contract forms available to us as standard? Sure. But are we allowed to put those together, reference them each? Is that good enough? Or do we need to have an attorney draft a customized document for this lease with option to buy situation? What do you think? Exactly. That's too much. A lease is a lease. Contract is a contract. We have access to each of them, but we can't put them together. It would need to be a custom-made lease with option to buy contract, not something that we can cobble together from the things that we have access to. So watch out for that sort of thing too. An option to purchase, same thing. Need to get the attorney to draw up the option to purchase. Even just a simple option to purchase. That's no standard form that we have access to. Where can we get contracts? As we'll see when we go through the slides, we can get them from the Realtor Association. That's part of our benefits. It's included. For $700 a year, it should be. Right? It should be. There's lots of things that we get for that, and this is one of them. Non-realtor brokers. What if you're a broker? Can you do this business and help people buy and sell houses if you're not a realtor? Well, legally, yes. Is it going to be hard for you? Yes, because that might keep you from joining the MLS. It might be hard to find a real estate firm that doesn't require you to be a realtor, because if the firm is a member of the Realtor Association, all the brokers within that firm have to belong as well. So it's pretty tiny array of choices. But if you are a non-realtor broker, you can't use the forms either. Just because you have the license doesn't mean you can use those forms. It's your membership to the Realtor Association that lets you use those forms. Those standard forms I'm talking about that have that realtor logo on them. See, there's a lot of little nuggets in this syllabus. I really hope you're paying a lot of attention to the syllabus. Also, if you're not a realtor, but you do have a license, you can, you may obtain and use the contract forms and standard addenda jointly approved that bear only the North Carolina approval through an attorney or forms vendor. Okay. So you could get forms to use through an attorney or somebody who sells forms. So that is allowable. That's the difference here is it a form that only has the realtor logo? Then non-realtors can't use it. But is it a form that has both the realtor logo and the bar association logo, meaning attorney, groups of attorneys? Then yes, you can use it if you get it from an attorney. The commission doesn't create those forms, though. Who creates those standard realtor forms? The Realtor Association, not the Real Estate Commission. So the things like the offer to purchase, the listing agreement, the vast majority of forms that we can fill in the blanks of are provided by the North Carolina Association of Realtors. But there are 3 forms that are made and created by the Real Estate Commission. Don't get that one wrong. Don't think that the Real Estate Commission creates and provides all those forms. They don't. They only create these 3. The disclosure ones right there in the middle. The working with agents disclosure, the RPODs about the property itself, and the mineral oil and gas rights disclosure. Those are commission generated. Therefore, you can find them in the same place as all those realtor forms, but also on the Real Estate Commission website. And you can give these to unrepresented sellers and buyers because these aren't realtor specific. These are for everybody. And even a for sale by owner seller has to provide this thing, both of these things. Even if they have no agent involved, they still have to provide these documents. Now, do they? I bet a lot of them don't. And don't ever know the difference, but they're supposed to. And it's a good way for you to kind of break the ice with them. If you're trying to make a good impression on a for sale by owner, to try to maybe get in there and list the property, if they get frustrated, as long as they're not on the do not call list, then you could say, hey, let me help you out. Here, these forms are required. Here they are. No fee, no cost, just my gift to you. We're going to talk about the contract itself and how in order for a broker to fill in the blanks, for it to be a contract that we as brokers are allowed to fill in the blanks of, the Real Estate Commission requires that it has 19 specific things. Now, for those of you who just thought, oh no, I got to memorize 19 things, I've got good news. You don't. You don't need to know those 19 things. You just need to know that there are 19 things. You can't just have any old fill in the blank contract and be involved as the broker. Your client, your seller or buyer could indeed have a contract created by an attorney or buy one from like Staples or Office Depot, but you can't help them with it unless it has these specific 19 things. If you're curious about what those things are, you can find them in the laws and rules, but there are specific 19 items that need to be on any contract that we involve ourselves with as brokers on behalf of our clients. This is a big one. There are two things that cannot be in that contract. We mentioned it, I think, last week. Any sort of mention of compensation. That contract, offer to purchase between buyer and seller, is just between the buyer and seller. It should not involve our money at all. Where do we establish what we're making? Tell me, how do we lay down and get in writing what we're expecting that we're going to make? If it's not the contract itself, what document says and protects the broker's commission? Yeah, Chapter 7 and 8, agency agreements. The listing agreement says this is what we're going to pay to the brokers. The buyer agency agreement says, hey, buyer, the agent's going to try to get paid from the seller, but if they don't pay him enough, then you're going to have to make up the difference. So the agency contracts is where we nail that down, not the offer to purchase and contract. I had that happen to me last year. An agent brought me an offer, and in that offer, she wasn't happy that her buyer agent commission was 2.5%. She wanted it to be 3%. And so she wrote in the contract, see Addendum A. Look at Addendum A. And there it is. So right there in the middle, where you can just put whatever thing you want, she had written in, see Addendum A, and she had actually created this thing, and it said, buyer agent to receive 3% commission. And the little lights in my head went off because I do this all the time. And I'm like, no. And so I very politely, professionally had to say, I can appreciate how you feel. However, if you recall, we can't do that. You can't put the compensation. The commission is not supposed to be in the contract. So people get this stuff wrong all the time. That's a big one. What else can't be in the contract? You remember? Anything about our compensation, but also anything that takes responsibility off our shoulders. Liability disclaimers. And that might be the broker does not have to attend the inspections. The seller agrees to let the buyer be by themselves with the inspector when they have inspections. That happened to me last week too. Had a 15-page, or not page, but item, 2-page, 15-item addenda to an offer to purchase. And they said those two things. They said that the buyer agent doesn't need to be there for the inspection. Seller gives permission and acknowledges that that's okay with them. Do they have to? No, not legally. But it wasn't just that. It was that they also put in, you better leave that house clean and clear of debris. And in order to prove it, a seller agrees to provide 15 to 20 photographs of these rooms and following areas of the house to be provided to the buyer agent. And I'm like, so you want other people to do your job? In my mind, that buyer agent should get their bottom out there and check that house and look through it and make sure it's in the condition that their client wants it to be. But they're trying to shift that right on over. You know what's going to happen? If the seller were to agree to it, the seller would look to me, the listing agent, to do that task. And I'm like, I mean, I'll do it if the seller wants to sign it. But I'll bet the real estate commission would have a problem with it because this was a sight unseen offer on a coming soon status listing. And so that agent hasn't even seen it. They're not allowed to see it yet till it goes on the market. And then these other two provisions they're writing in that also indicate they're not going to go see it. Sounds to me like they're never planning to see it at all the way through closing. And the commission has a big problem with that. They say that's legal, it's allowable, but if you get in trouble, that won't be a defense. If the buyer buys it, finds out that there's all kinds of problems with it that could have been noticed by you for having gone and looked at it, you can't say, well, I didn't go see it, so therefore don't sue me, bro. Don't discipline me because it's not my fault. I didn't see it. Well, it's not you didn't see it because you didn't go out there to look at it, right? So that could be a big issue, and it could fall under this category. They're writing in basically sort of some disclaimers. Goes into more detail, and then we are going to actually look at the most commonly used addenda and the actual offer to purchase. We've already looked at several parts of it. So definitely between now and next week, that's your homework. Read through this syllabus if you haven't already, and just really look for it and write on it and make it into a review, because it's pretty lengthy because this is a 7-hour section. But let's go look at the actual slides. They're a little easier to digest. We've got George decides to sell his personal residence and offers it in a letter to Larry for $350,000. The next day, George gets a note from a neighbor, not Larry, but a neighbor, and says, I accept your offer to sell your home for $350,000. Is George obligated to sell to the neighbor? Let's just start with this. Yes or no? Why not? Because the neighbor accepted George's offer, so he does? Or yes, he does because Larry can always assign the offer to someone else? Or no, he doesn't because George didn't make the offer to the neighbor? Or no, because the neighbor did not wait for Larry to accept or reject first? Which no? He's selling his house. He writes it up in a letter to Larry, specifically to Larry, says, I'll sell it to you. Oh, I think I'll change the price on you. Sell it to you for whatever the price is. The next day, he gets a note not from Larry that he made the offer to, but from a neighbor. That neighbor says, I accept it. Who was the offer written to? Yeah, it's number 3. George didn't make the offer to the neighbor. This cannot be an accepted contract at all because that's not who he offered it to. So it's got to have the right parties on there. There it is. Didn't make the offer to the neighbor at all. In this chapter, we're going to look at installment land contract. Spoiler alert, it's seller financing. An option to purchase, preemptive rights. Couple of the major provisions of the standard offer to purchase, and some level 3. And the procedures that we follow. So tell me this, in a typical transaction, which is the most important document in a transaction? Is it the deed or the contract? The deed or the contract? We might have mentioned this back when we were talking about deeds. So you might remember that. They're both pretty important documents, and it's really tempting to think about chapter whatever that was, 2, 3, about deeds. But what is the deed? It's that document that says this seller is selling to this buyer in this manner, conveying ownership from this seller to this buyer. Who signs the deed? Yeah, it's transferring title. That's the best way to say it. Thank you, Joseph. The grantor, the seller, the giver of the deed is the only one who signs the deed. But what does this deed look like? looks something like this. It shows who prepared it up at the top. The one who does the recording of the deed has this space available to him to put a stamp, to hit it with a stamp and say, this deed has been recorded as of this date and time. And they'll talk about the excise tax, because don't forget, another term for that is revenue stamps, and that's handled when you record the deed. And then it shows this. This is the property at this location. Identify the property. And says insert legal description here, and talks about the grantor right there and the grantee down there. And then there's a couple other pages. I'm not sure if I have access to those. Let's see. Find another one. Here we go. They're not giving me what I want. I'll pull one, show you later. But that, where do we get the information, right? Where does the attorney get the information they need to put on that deed? How do they know the names of these parties? Oh, there's a good one. How do they know who the parties are, where the information is? Here's one. North Carolina General Warranty Deed. There's the grantor. There's the grantee. There's the, look, they got a meets and bounds description. There's a real deal beginning at northernmost point of such and such acre tract described in this book on this page. Go north this many degrees. Minutes and seconds or others are also a version of degrees. There are sub-degrees, in other words. Still a directional sort of thing. And so it goes in and talks about how many total acres it is. And then we get to the next page. They're keeping, look how long this meets and bounds is. And then finally, at the last of it, the notary public signs it, stamps it. Do we remember that it was a non-essential element of a deed that it be notarized? But yet it's a good idea for it to be notarized. It doesn't make it any less of a valid deed because it's not, but they are. They are because it's just a smart idea. Shows when it was signed in the presence of this notary public. And then here's that signature down here somewhere. Oh, they reference a book and page in the county. There it is. And there's the seller's signature, the grantor's signature. So that's the deed. How did they know the name of this seller and the deed book and page and the legal description? They got it from the contract. So therefore, what's the most important document? The contract. I think we talked about that once upon a time. Because that sets the terms of the agreement, establishes the legal rights and responsibilities. Therefore, it's more important than the deed because it dictates what goes on the deed. It's more detailed than the deed as well. So we can't draft legal language. We can't draft sales contracts. That would be unauthorized practice of law. North Carolina real estate license law prohibits it. Not allowed to do it. We do need to know what to use. There are two provided contracts. There's one when it's a property that's got an improvement on it, like a house. There's also one that's just for land. There's a land-only version of the contract. So we need to know the difference. And one time, I heard from a buyer who was trying to buy it on their own. They were buying from a for sale by owner. They were the sister of a past client of mine. And she said, just call Neil, let him help you with it. And they didn't want to pay me to help them with it. And so, but they kept calling. The lady did, but not the husband or the boyfriend. He was trying to do it himself. She kept getting kind of scared and said, let's just get Neil to help us. I was willing to do it for less than what I would charge for a full buyer agency commission because I was only needing to do the paperwork, really. But they just couldn't bring themselves to let me do it. And at one point she said the seller agreed to give us a home warranty, but I don't see it anywhere on the contract. There's nowhere built in on the contract for there to be a home warranty. And I thought, well, there should be, because there is. And when I finally figured it out, I realized it's because the seller had been given a contract to use from a friend of his who was a real estate agent. Pause, as we all realize, wait a minute. Did you just say an unrepresented seller selling to an unrepresented buyer was using a realtor form? Yes. Given to him by a realtor? Yes. So already we've got a realtor doing some dumb stuff. Secondly, the thing he gave him was the one for vacant land, not for houses on the property. And so land doesn't have warranties built in. There's no warranty company that will warrant dirt, right? So that's why. And then I was all the more like, see there? Don't want to say I told you so, but there it is. The version just for land, it specifically says at the top, somehow they missed it. Offer to purchase vacant lot and land. So they had filled this thing out between them illegally, improperly, no agent involved. And there's nothing in this 13-page form about selling dirt that involves a warranty. But a lot of similar provisions, though. We see the place for due diligence fee and initial earnest money. We see additional earnest money, and all that's the same stuff. But it's going to be very land specific. But pretty similar besides that. We'll look more at that later. So knowing the difference and knowing which forms are needed when. Let me see. Your office will usually provide you with all the forms because they get them from the same place we all have access to. But look at them. I mean, we've got, here's where we can always get them. If your office is late or behind on providing them or putting the most recent version, or maybe they haven't included every single one, you can go straight to your login for being a North Carolina realtor. Go to the realtor website and log in and just look. Here they are. Auction-related forms. There's 16 of those. There's 14 buyer-related ones. There's 96 commercial ones. There's 157 contract-related forms. Anybody counting? Joint forms, 44, 31, 12, 8, 52 property management related, 24, 158 sampled. Here's the cool part. Most all of these forms have a version with the word sample already put across it. So you can give people samples to look at without worrying that they're going to try to use them. They can't use them if they have the word sample written on it, and so you don't have to write it yourself. Seller-related forms, 26, and these all include the agency stuff too. There's some Spanish translation major forms, some of the main ones, 8 of those. And so plenty. There's a ton of them that we have access to. Just click it and it opens it right up. We just need to know when to use them. And so that's a big one. That's the thing you're going to learn after you pass the class and pass the PSI and get into the firm. They're going to give you some boot camp training and then that's another reason that you need to lean on that BIC for a handful of transactions. Even if you take all the post classes in the first month or two, you're still not going to have had a time to experience the various things that are going to require you to see these various forms. So I'd say it's going to be a good year at least before, it depends on how busy you are, before you will have kind of encountered most of these things. We get them through NC Realtor Association. Again, most of them are provided between them in association with the bar, but the members of those two groups are only the ones allowed to use them. Here's what the commission says about filling them out. Be legible. Fill in all the blanks. Don't leave something empty. I see that a lot. Empty things. That makes me nervous. When people are signing contracts with empty blanks, could somebody go back and stick something in that blank and it looks like both parties agreed? That's what I think. So I'm like, let's put NA or 0 or something acknowledging we have ignored that blank for a reason. It's been addressed. And then precision. Commission says make sure you're precise. Don't use jargon or abbreviations that nobody understands. Remember, it needs to be clearly understood. And then no ambiguity, no unclear language. That's the commission saying to us how we have to fill out forms. And don't forget this one. Statute of frauds means what? What is it that a document has to comply with the statute of frauds? It must be written in order to be enforceable. There you go. Thank you. There we go. There's old Judge Judy. That's what she's going to ask about. What does in writing mean? We know this already. We learned this last chapter. E-signing, electronic signing is fine. That's allowable. Now, occasionally a lender might say it's not good enough for us. Certain documents that the lender requires, they might say it has to be a wet signature. But as far as the contract itself, it's still a legal contract if it's electronically signed. So we can save some trees. What's the most important document in a transaction? Not the deed, but the contract. If a term needs to be added to an offer to purchase, what the broker should just write it in, true or false? Is that good enough? We just add in what we need? We may not. Good job. It all starts with this thing. The offer to purchase and contract. There's 19 provisions in the printed contracts. You don't need to know them. You just need to know that they exist. And by the way, again, the buyer and seller parties to the transaction, they can write them themselves. But it's not advisable. They can write them themselves, but they should probably get an attorney to do it. We talked about this already. Disclaiming our responsibilities and however much we're making cannot be mentioned in the offer to purchase. If a buyer is using the standard offer to purchase and contract and decides to back out after the due diligence deadline, what happens to the money? Does the buyer get the due diligence fee back? Do they get the earnest money back? Do they get nothing back, or do they get both back if they are outside of the due diligence period? That means it gone past the due diligence deadline. Most of you got that. Yeah, they're getting nothing. They are already out of the due diligence money. They had to write that out directly to the seller, by the way, in the very beginning, and now they're also not getting the earnest money back. We talked about this already. Got to have that property description in there. It's going to be everything you can possibly put in to identify the property. Certainly the address, even though that's just an informal reference, it's not officially a legal description, but you still need to put it in there. And definitely a legal description as well. It could be what? What are the different kinds of legal descriptions allowed in North Carolina? We saw meets and bounds a minute ago. We could also reference a couple other things. We could reference two things. What could those be? Yeah, book and page of where the recorded plat is or where a previously recorded deed is. Those are both, all three, legal descriptions. Plus the property street address is an informal reference. What does that contract need to have in it? You tell me. Let's unmute, speak up. Tell me what a contract needs to specify. What sorts of things need to be on an offer to purchase? What sorts of information? For sure. Definitely sales price. Good one. Did you say the size of the lot? Gotcha. Square footage, acres. Now, in the contract itself, it's not going to have those things specified. They're not going to be specifically in there. It's going to, by referencing the legal description, that's how we're going to refer to that. Legal description and address. And then we go look at the MLS listing. That's how we will know those things. But there's not a place for these items in the contract necessarily. Maybe a custom one, but not the standard one that we use. What else? Oh, sure. Known issues. So a couple things with issues. It could be that if we include an addendum, like that additional provisions addendum where we say, hey, we want the seller to fix or replace the carpet because we know that that's old. So things like that. It could be that we have the right to inspections, right? That's part of it. What about this question? Is this offer an as-is offer? Or here's a better way to say it. Are all offers as is? As is. What's that mean? Take it as it sits, right? Now, it specifically says in the standard offer to purchase that it is, all of them are as is. However, it says the seller could choose to fix stuff if agreed. But officially, they're all as is. Are we going to negotiate repairs? Victor says it depends. That's true. It does depend. Depends on, in a market like this, do you think sellers are fixing things as much as they did 10 years ago? No. So it depends on the deal, the market, the seller, the buyer. Or the seller might just be old school and have pride of ownership and say they just couldn't sleep if they didn't fix even that loose doorknob. I've had a few sellers like that, and I had to say, you know what, guys, I appreciate that. You're very, very, very responsible and cool, but you're not obligated to. Oh, I know, but we just couldn't help ourselves. So you run into that sometimes. That's a good one. Zentosh says things that are included, like fixtures and not included. Fixtures and personal property. Definitely. That's in that offer. What else? Did I miss something? Proof of funds. There you go. We're going to reference a proof of funds or a pre-approval. If it's a loan. What else? Effective date. Absolutely. Let's think about related to that pre-approval letter, though. What else maybe related to the loan might be in there? What other loan types of information might we have in that offer to purchase? Yeah. The type of loan. Do you think that seller deserves to know if it's an FHA or a conventional or a VA or something even different? And so if you've got 3 different loans or 3 different offers, each that's one of these, what do we know? We don't know anything yet because we haven't got to those chapters 14 and 15. But what we're going to learn is conventional loans are going to require the best credit. Going to have pretty good credit. VA and FHA don't need to have quite as good of credit. Still decent, but ideally, even if you qualify for an FHA or a VA loan, when we get to those chapters, we'll talk about this. have your client try to get a conventional loan anyway, because it's always going to be a cheaper loan to get, less fees, because it requires better credit and more down payment. These don't require any down payment. That could be zero on a VA loan. FHA could be 3.5% down. Conventionals typically at least 5% down, although there are some other programs. If you have really good credit, you could maybe do 3 or maybe even 0. But it's all very credit driven. Can we not give a loan to somebody because they can't afford to pay the loan? Yes. You can discriminate against somebody based on their affordability. That's a weird way to say it, but it's essentially what we're saying, right? Affordability is not a protected class, right? So that's why these things matter. So that seller sees one offer come in that's the conventional loan, another one with an FHA, another one with a VA. If that seller is worried about this sale going through successfully, nice and smooth, they might lean toward one of these over the others. Which one do you think? If everything else is the same, like even if the price is a little more for FHA or VA, they're getting a couple more thousand, they might still feel better about the chances of a successful closing with a conventional loan. And that's exactly what we've seen these last 3 or 4 years. It's been sad. A lot of FHA buyers are always in the market because a lot more people have credit issues and less down payment than do. And so they've kind of been losing because sellers picked the one that was in their best interest, and it tended to be the cash or conventional financed options. So therefore, is it important in that offer to purchase to tell the seller what the buyer's going to be doing? Yeah. The seller deserves to know. Now, some sellers might say, well, that's exactly the reason I did pick the VA person, because I felt bad for them and I wanted them to have a chance. Okay, fine. That's your choice. But if it's a seller who's worried about closing day, what could go wrong on FHA and VA? One thing that could go wrong is the house isn't in good enough shape, because the FHA appraiser isn't going to authorize the FHA loan if the roof is bad, if the windows are broken, if there's big holes in the wall, and if there's no range, no oven, and if there's peeling paint down to the wood. We'll talk more about that later. So if that could be a thing, I've got a new listing coming up is a 1992. It's got a lot of deferred maintenance, meaning some of the siding is rotten, the roof is kind of old, and we're not even going to offer it up to a buyer using VA or FHA financing because we don't want to worry about that. We don't want them to waste their time either. If that FHA buyer comes along and gives my seller $10,000 due diligence money, and then it turns out the appraiser says the roof needs to be replaced, my seller can say no. But they're not going to be able to buy this house because the loan won't work. Well, guess what? They're still out $10,000. Mm-hmm. Yeah. Was this in North Carolina? Yeah. Yeah. And there's also some things that are required that the seller pays for when it's a VA loan too. You might have been alluding to that. But yeah, so it's a lot involved. So therefore it looks like this on that, offer. It shows what kind of financing, or is it going to be cash? I'll find it in a minute. Oh, I know. I have to do my search. There it is. Used to be at the bottom of the page. Now it got moved in the new version to the top because they are always adding things. So, Buyer representations. Are you paying cash? Check the box. And if they do intend to pay cash and don't plan to get a loan, are we providing verification of that cash? Yes or no? Is it attached to this or not? So there's something for everything. The buyer does not need to get a loan. Seller is advised before signing this to get documentation proving that they can actually close without the loan. Proof of funds letter. And then if it is going to be a financed situation, check this box. And are they going to get a first mortgage is it going to be conventional or USDA? They don't even have FHA and VA written in on the new version. You would put that in yourself. There might be a second loan. Sometimes there's two loans. Sometimes they need to get money from another source. Anybody have an idea? We're kind of getting into the loan side a little heavy, but what might be a situation where we would talk about another source besides just a loan? Anybody? Yeah, it could be hard money if it's an investment property. Hard money means you're borrowing from an individual that's charging you probably a higher interest rate, but it's a short-term loan. It just lets you grab the deal, but you're paying a premium for it, but otherwise you couldn't, right? Could be family. That's a great point. A gift from mom and dad. So therefore we need to see a gift letter, have proof that mom and dad are really going to give it to them. It could also be, anybody heard of NACA or any sort of government sort of program for people that have a certain threshold of income? So that sort of thing, in addition to the down payment, they're going to get some gift money or get some grant money, something like that. All that is spelled out. So what else would need to show up in an offer to purchase? We are continuing our list. What other sorts of things need to be in an offer to purchase? My list is not neat. Due diligence, earnest money, you bet. How about this? What if it is a buyer who doesn't have any extra money? All the money they have is what they need to use for the down payment. And as we'll learn in chapter 21, there are buyer's closing costs. There are loan fees, like something called an origination fee, maybe discount points. In other words, we need to spell out if the buyer is asking the seller to pay some of the buyer's closing costs. That's a thing. So we acknowledge that, hey, this might look like an attractive offer, but on the first page, it says the price is higher than asking price, but let's see, where'd it go? On the subsequent page, it acknowledges, oh, wait, that's only if the seller pays some closing costs. So it's actually going to be that price you're offering minus this credit. Let's see if I can find it. There's a blank toward the back. There it is. That says the seller shall pay at settlement blank dollars toward any of the buyer's expenses, including FHA or VA and inspection costs, lender costs that the buyer's not permitted to pay. Sometimes that's a thing with those government-related loans. So, yeah, on the front page, this is page 7. On the first page, we saw, oh, we're asking $300,000. They're offering $310,000. Oh, great. They're offering more than we're asking. But then we roll on over here to page 7, and it shows we want $12,000 in seller paid closing costs. Oh, this isn't an offer for $310,000. This is an offer for $298,000 because $310,000 minus 12 is $298,000. Oh, and they also want the refrigerator and the washer and the dryer. So the seller's going to have to go buy new ones of those if they agree to this too. So now it's like more of a $296,000, $295,000 kind of a situation. Oh, and they want everything fixed. Okay, this isn't a great offer anymore, is it? We see that more in the neutral market or more buyer-centric market. Our break snuck up on us. Let's go ahead and take a 10-minute break. See you back here. Welcome back. Let's talk about earnest money. Talked about that a little bit already. We know that it is good faith money. It's showing that we're serious. There's two different checks, right? There's due diligence money and there's earnest money. The due diligence money is, well, we know that it's liquidated damages, but it's also, I guess you could say, I don't like this definition, but it's the amount of money you're paying for the amount of time called the due diligence period. Although that's not 100% the best way to say it, because you don't have to have any due diligence time and you don't have to have any due diligence money. So it's not that you are buying the time with the money, because what if you want the due diligence period, but you're not offering any due diligence money? That could happen. Someone could make an offer and say, well, I want to have time to do my inspections, but I don't want to give you any due diligence money for that. I doubt they'd get away with that right now in this kind of market. But in a buyer-centric market, even in a neutral market, maybe. They might. But earnest money has been around longer. It's been around forever, and that is just showing some good faith. Who do we give the earnest money to? When we get that check from our buyer for the earnest money, where does it go? There it is. It goes, that's probably the best answer out of the ones there in the chat, is in the trust account. In the trust account of whoever's holding the money. Let's look at how that shows up. We've got our due diligence money. We've got our earnest money. The due diligence money is written out to the seller, but not the earnest money. That's written out to the escrow agent. Not agent like real estate agent, but it might be the real estate firm. It could be the attorney who's holding it in their trust account. It could be one of the firms involved that's holding it in their trust account. So we need to make it out into the name of the one whose trust account it is. If it's ABC Realty, it needs to be made out to their name so that they can put it in their trust account. If it's Happy Valley Attorneys, it needs to be made out to their name in order for it to be put into their trust account. So what else? What else do we know about the differences here? Who is it made out to? Also, is it refundable or not? Is due diligence money refundable? Non-refundable. But earnest money is. Could be. This depends on the time frame. Earnest money is good faith money. Due diligence money is, you could call it decision money. Sort of like, am I going to do it or not? Buy or not? Because the question we're asking during that due diligence period is Will the buyer proceed with this thing all the way to closing or not? This is the amount of time that they have to back out for any or no reason. And then they're both called liquidated damages in the event of a buyer breach or the buyer choosing not to buy. So earnest money, good faith, buyer serious. It's not required though. It's not an essential element. It doesn't make or break the contract. Does the giving of the earnest money to the escrow agent have anything to do with whether the contract is a contract? Does it make or break the property being under contract? No. The money delivery has nothing to do with it. It is also not an essential element. It's also not consideration. They might say, which of the following constitutes consideration in a transaction? Well, not earnest money, not due diligence money. The consideration is the purchase price at closing, essentially. A couple things about earnest money with regard to the trust account, which is where it's kept. It needs to be deposited in that trust account within 3 days of receipt. When that escrow agent receives it, they've got 3 days to deposit it into the account. They can't just hang on to it the whole time. If there is a dispute about how it will be dispersed, like if the buyer chooses to back out within the due diligence period and the seller says, well, I'm not giving it back to you. Even though it's written out in the contract that they're supposed to, they could refuse to sign the release form. And we can't do anything about it as the broker. In order for that money to be released, the parties, buyer and seller, would both have to agree in writing, sign the form. It might be that they do that for a week or two, and then finally they're like, let's just be done with this. Maybe the buyer says, you know what, I know I'm supposed to get all of it back, but at least some is better than none. And rather than let that seller tie this up for who knows how long, and I'm trying to buy a house, let me at least get half of it back. Would you be okay with that, seller? Let's split it. That could happen. The parties could agree to split it in some amount, maybe not 50-50 in some amount. Maybe the buyer's in a hurry and they acknowledge, or they're saying it's the principle of the thing, I'm mad about it, I'll just do whatever it takes. But maybe they have a goal to buy a house, and $5,000 is better than nothing. It's $10,000 total. I keep saying 10, but it's not necessarily. It could be 1,000. It could be 20,000. But if the money's being held in the firm's trust account and that broker in charge who's responsible for the trust account gets tired of it being there because this is now a dead deal that's never going to pay out, they don't have to keep it there forever. What can that broker in charge or the custodian of the escrow account, if it's an attorney, whoever it is holding it, what can they do with it? Do they have to keep it in their account until the parties agree? They might do that for an amount of time, but they could ultimately say, hey guys, here's your notice. You have 90 days to work this out. If you don't want to work it out between you, I'm not holding it anymore. I'm going to turn it over to the clerk of court in the county, and then they will reach out to you. And if you can't work it out with them, they'll just keep it eventually at some point. The court will decide who's going to get it or keep it. Effective date, we know, is a very important date. A lot of dates in the contract, a lot of deadlines hinge upon it. It's when, the last party signs and initials, and communication has gone back and forth to the other party that we have an executory contract. It's both of these things. A smart move is to make sure this is happening on the same day, so the date on the paperwork matches the date of the communication, because it could get complicated to have to go back and find an email from the day after that was actually the first communication. But that could be. Right? It's both of these things, not just the last date on the contract, but whenever that date of signature was communicated. That due diligence period is when the buyer can investigate. do their due diligence, do their inspections. Let their uncle from Arizona fly in here and make sure that he likes how it looks because they trust his opinion. For whatever reason, they need to figure out, are they going to move forward with the purchase or not? And in exchange for that amount of time, there's a due diligence fee. Although that fee could be zero, it's usually something, and it's a negotiable amount of money paying to the seller on the effective date. The buyer's sort of paying for that amount of time to do their investigation. But as we saw, the due diligence fee and the due diligence period, neither are required. They could negotiate. It could be zero. They're paying it to the seller. Don't mess that up. The escrow or the earnest money is not paid to the seller. The due diligence fee is paid to the seller. Can the seller spend that money as soon as they get it? The due diligence money, can they spend it? Sure, it's non-refundable. It's like a pet fee. Can the landlord spend the pet fee? Yeah, because that's non-refundable usually too. So certainly, the only way they might have to give that back is if they breached themselves. Did I hear a question? Yes. Perfect. Good question. So it's not whipped cream on top of the ice cream sundae, right? It's money that goes toward the purchase price. So when the buyer gives that due diligence check to the seller of $10,000 on a price of $300,000, that means they're going to need to bring $290,000 to the closing, right? It's not extra over and above the price. And that helps the buyer to stomach having to pay these higher due diligence monies. You know, it's like, I know it's $50,000, but it's that much less you need to bring to closing. Same for the earnest money, by the way. The earnest money is also credited. It's that much less they need to bring to closing. And with the due diligence period, as we saw, time is of the essence. So it expires at 5 p.m. on the date agreed upon. So what if the buyer, let's see, let me take a look here. Yeah, the buyer can terminate for any reason or no reason. What if the buyer decides they don't want to go through with this sale? What should they do? In writing, on the day of due diligence, by 5 p.m., they need to send that notification over and say, just letting you guys know, not buying it. Give me my earnest money back. If you don't, what happens if the buyer agent does not get that signed and sent over to the listing agent by 5 p.m. on the due diligence deadline? What's going to happen? Yeah, they're still under contract. The earnest money is now out of play, so to speak. Now, if the buyer decides to back out at 5 p.m. and 1 second or later next week, 2 weeks from now, day before closing, anytime from here forward, once that deadline hits, then they're also walking away from the earnest money. So what if the reason that they decided, what if we're still in the due diligence period. We had inspections done, and the inspections revealed that the roof is leaking, that there's some broken window seals, like it's foggy windows. There's some mold issues. There's probably about $6,000 worth of repairs needed. And so we prepare a due diligence request, basically a repair request. We want you to, hey seller, we want you to fix these things. Have a professional fix these items. And they've been thinking about it for 3 or 4 days, and now we're on the day of due diligence deadline. We still haven't heard anything from the listing agent or the seller. And now it's 4:45 p.m. Coming up on the 5 p.m. deadline, still no response about whether they'll fix anything or not. What if it gets to 5 p.m. or later, and we never got a response, and the buyer never backed out and terminated? What are they saying about those repair items? What's going to happen to the items that the buyer wants to be fixed by the seller? Yeah, they're just basically saying you don't have to fix them now because I didn't terminate the contract and we didn't get anything in writing saying that you were going to fix them. So the buyer has nothing to stand on, right? So you as a broker in that moment, that's your priority that day. Make sure we get this thing covered. And if you never hear from them and it's getting close to 5 and it's a big enough issue for your buyer, you're going to need to ask your buyer, is this a big enough issue for you to want to back out? Because we need to back out in the next 15 minutes. Please sign this termination of form so we can get it to them before 5 so that you don't have to buy this thing since we don't know if they're willing to fix the things that you want them to fix or not. See how that could kind of get a little stressful? And you got to stay on top of that. And then 4:58 p.m., you get the response and the seller says, yeah, I'll fix everything. Sorry, I didn't notice this. But you've already sent the termination. It can get a little tricky, right? You won't get it tested on something like that. But in real life, communication is key, right? You would want to do all you could to communicate with that listing agent. Hopefully it doesn't happen that often that we get down to the wire like that, but you need to be ready. You need to be ready and help your buyer understand, are you really serious enough that you want to walk away if we can't get this resolved by the deadline? Because you're in jeopardy of losing the earnest money if you back out later. If we give them another day to decide if they want to fix stuff, then let's renegotiate the due diligence deadline. Hey, we'll give you through the weekend to get some more quotes, Mr. Seller, but we need to push the due diligence deadline over till Monday, right? Because we still want to reserve the right to back out if you won't fix everything the way we want you to, essentially. Now, whose decision is it to allow the extension of the due diligence period? Is that mutual, or is it more of a seller decision, or is it more of a buyer decision? Yeah, it's the seller's decision. So that buyer would need to ask them in advance before 5 o'clock, hey, we either need more time because we need it or because you've taken your time, dragged your feet, given us an answer. But if you want to keep thinking and you don't want me to walk away right now, then I need a decision or an extension. Now, the sellers might have a bad attitude and they might say, well, feel free to walk. I'll keep your $12,000 due diligence money, put it back on the market and get another $12,000 or whatever somebody else is willing to give me for due diligence. And a lot of sellers enjoyed that privilege, sadly. Occasionally I'll have a pre-licensing or post-licensing student that's still a little sore because that happened at their expense. They tried to buy something and the seller totally came out on top because they had so much due diligence money in the mix. And the seller just kind of let them walk. But when they walked, they had to make a hard decision of how much money were they willing to walk away from. It became a lot different of an animal in these last few years. But even, back when the rule of thumb was 1% of the purchase price on a $400,000 house, we're talking $4,000 for combination of earnest money and due diligence. That's still a lot of money. But when that became 10 and 20 and 30 and 40,000, it just changed all kinds of things about the dynamics. And much less likely, is it more likely or less likely that a seller is going to fix things that need fixed when you've got $50,000 of due diligence? A lot less likely that we see seller paid repairs, right? Did I tell you my nightmare worst case scenarios I heard from the CE students of due diligence money? And I always ask them just for fun because it's a nice cross section of the market. And I ask, how much are you seeing out there when you received it as a listing agent in an offer, or you wrote it up on behalf of your buyer for due diligence money? Any guesses? What are some of the biggest due diligence checks that people had to write, do you think? I've heard 100,000. Yep, I've seen that several times. But this one person last spring, a year and a half ago, I guess March of 22, said $400,000 of due diligence money, non-refundable. And of course, the natural next question is, well, Was that on like a $2 million purchase price? Because that would kind of be expected, but no, it was on a $400,000 purchase price. That's a buyer who's tired of losing offers. I guarantee that buyer lost several in a row, and he's fed up with it. And he said, I'll do whatever it takes. Here's all the money. Now we just need to get the title search and a couple things done, and I'll see you at closing in a week or two. Right? It's also a seller who's probably not going to fix anything. It might even be a seller who gets to pay off their mortgage, whether this deal closes or not. I've heard those stories too. The transaction falls through, the seller ends up with a paid off house. Oopsie. Oh well, poor me. Had to try to sell my house and failed at selling it, but then I paid off my mortgage. And it kind of makes me think the seller's attitude, some of them might be, please walk away. I don't mind if you walk away at all, because I'll just get another buyer with another due diligence check. Now, at the end of the day, sellers still have timelines for the most part. They do still have plans and reasons they want to get this thing done, but it probably doesn't hurt their feelings. It's not that worse of a worst case scenario when the money is that big. So, due diligence fee and period. Buyer can terminate any reason or no reason, but they need to submit it in writing to the seller no later than 5 p.m. Seller keeps the due diligence fee. They were getting that anyway. They already have it. The earnest money is returned to the buyer if they back out within the due diligence period. If they back out after it, the seller keeps both. What's the minimum amount a buyer can put down for due diligence money and earnest money? Minimum amount allowed. Well done. Everybody's staying awake. I love it. You got it. No minimum. Zero. Could be zero if you can get away with it, if the seller would agree. And if we were in a buyer's market as lopsided as this seller's market is, we'll see that. I guarantee we will see zero due diligence and maybe even zero earnest money from time to time. Settlement. We have a whole chapter about settlement, but what it means is the time at which the papers are signed. Signing and delivering of the necessary documents. Settlement is not closing. We hope it is. We want it to be on the same day, but closing is going to be a couple hours after the settlement, if it's a loan especially. Because if it's a mortgage that's being used to buy this house, then the lender is going to want to see everything that got signed before they fund the loan, authorize the loan to be paid for and funded. Meaning the lender tells the attorney, okay, here's the money that they're borrowing from us. We're sending it to you. We're wiring it to you. Or we wired it to you yesterday and we're authorizing you to use it to pay the seller, to pay the inspectors, to pay for everything on this closing disclosure that needs to be paid for. And so that, in other words, when we tell our client, look, settlement is at 10 a.m. on Friday, but you're not going to get your money while you're still sitting there. It might take 45 minutes to sign everything. 11 a.m., you're still not going to have your money. Go ahead and make plans to go have lunch. I'll take you to lunch. Couple hours after settlement is when you'll finally get your money. That's the seller. And the buyer, you're not getting the keys while you're still sitting there probably, because all those things that you just signed, all those loan documents have to be scanned and sent up to the lender for them to review and make sure everything got hit, all initials and signatures. Then the attorney, once they get authorization that it's all good, goes to the courthouse, either in person or online, and records the deed. But before they do that, they make one more swipe and one more check to see that no liens, like a mechanic's lien, has been filed on the property. One final check, and then they record the deed. And that takes a couple hours. So it's not a good idea to surprise attack your client with this on the day of closing. If they're expecting keys, they might very well have everything they own on a truck and want access to that new house they just bought for $800,000 immediately. And let's explain to them how that's not the way it works a week in advance or a month in advance. like in the very beginning. No dirty little surprises like that. That just makes for an unhappy closing day. Not absolute. There's no time is of the essence for the settlement date. We saw it ourselves in person. We saw that it's built in with a blank that's flexible. And we saw in provision 12 that there's, in fact, an extra 7 days we could actually go beyond it if we have to. It's not we shouldn't look at it, though, like a built-in, hey, no big deal if we don't close on August 30th or not. We can just bump it. That it should be held in a higher regard than that. The commission says, don't just lean on it. Try your very best. If August 30th isn't a realistic date, then don't put it down. Put down the reasonable date, realistic date, but know that if things outside of the client's control cause a delay, that neither one can try to charge either or refuse to go along with an extension up to 7 days. Up to 7 days. That's good. Good for you. You bought a couple houses, and when you signed, you got the keys. That's probably because you bought from cool sellers. Because while it's not a requirement, it is possible. And if the seller wants to be nice, they could say, sure, what could go wrong? I'm pretty confident there's nothing going to pop up, no extra liens or anything. So yeah, go ahead and take the keys. So good for you. And a lot of builders, builders will do that too. They'll they just send a rep that you never even met. It won't be the on-site salesperson that you dealt with that whole time. It'll be somebody, maybe not even anybody. The attorney, a lot of times, is the builder's chosen attorney. They'll say, hey, we'll give you some money toward closing costs if you use our preferred attorney. And so it's you and your buyer agent, and then the attorney just gives you the keys because the builder authorized them to. So that is a possibility. Good point. But you as a broker need to always tell the parties to be ready. It could be a seller that doesn't allow this. They require the recording to happen before the keys are released. So settlement versus closing. Closing is what? After all that stuff is done, then the last final check of the deed for any liens, or the title for any liens, and then they record the deed. And once upon a time, if you notice, real estate attorney offices are within walking distance of the courthouse so that they could either walk themselves or send a paralegal down there to record in person. Now, I'd say 99% of them record online, but again, it's not like buying gummy bears off of Amazon at 2 a.m. You can't just do it online anytime. You've got to still record online within the operating hours. And so here in North Carolina, that tends to be closing down at 4 p.m. So if you don't get everything signed and ready to be recorded online by 4 p.m., it's not closing today. It's going to close on the next day the recorded register of deeds is open. And when we signed on a Friday afternoon at 3:30 and nothing's done and ready by 4, guess what? You're not moving in over the weekend like you tried to. And now your work schedule's messed up, the kids' schedule's messed up, the moving dates are messed up. And so closing could be a whole different date. So if it's an online recording that they're doing, they are logging in to the Register of Deeds and they're in line. They're in a queue. And I've sat in a closing before where everybody signed and the paralegal came back and said, well, we're 8th in the list. We got a few more to go. And in that case, we just hung out, me and the buyers. But a lot of times the attorney will have other people who need to get in there and sign, and they'll say, well, we need this room, so you go ahead and leave, go maybe to lunch or whatever, and we'll call you and tell you when it's recorded. And that's usually the way it usually goes. And so I'm looking for an email or a call, and it'll say, we are on record. We are recorded. You can tell your client to come pick up their check, or we'll wire it as they directed us to. Or you can tell your buyer to get the keys, or it might be that you've worked something out. Maybe the agent told you, and you're the buyer agent, they said, hey, you can take the key out of the lockbox, but don't give it to your buyer until we're recorded. And now, even though your buyer is your client, you can't give those keys to them if you've been told not to, right? Because it's not your buyer's house until it's recorded and closed. So a lot of flexibility there. Just depends on what everybody wants to be done. If the seller can't get out prior to closing, we need to do something with the paperwork. And it might be that the seller initially up front tells the buyer, look, I want to close on August 30th, but I don't want to move out until September 30th. That's kind of what I'm doing. I told the buyer, I want to close whenever we close, and I want 3 months after closing to move out. I want to still be able to live there. And they said, okay, well, you got to pay rent. And I said, no, I don't. And they said, okay, don't have to pay rent. So that worked out pretty well. So that's why. That's because I'm going to use the money to find a place to go, and I didn't want to commit to a new place until I knew for sure this one was closed and I had money in hand. And I had the power to do that because we're in a seller's market. But in that case, typically a seller is signing what's called it's called a seller possession after closing agreement. It's a miniature lease. It's like a little 2-page miniature lease. If it's the opposite case and the buyer asks to move in before closing, same idea, but it'll be a miniature lease that lets the buyer do that. So let me see here. Okay, good. Show you those things, because we're looking at these documents. Anyway, got to look at the addenda and the offer to purchase provisions. And so it's either a buyer possession before closing or a seller possession after closing. There we go. Let's look at this one. So this is the seller possession after closing agreement. We were allowing the seller to stay there afterward. A lot of these forms, you'll notice red and blue boxes. And these forms have grown quite a bit over the years because of these boxes in part, but they're great. The boxes really are helpful, especially for newer agents that are learning the ropes. They remind you of other things you might want to consider. And even for people that have been around a long time, it's just nice to have the reminders. So got a couple of built-in reminders. Warnings to buyer and seller. If you're doing this thing, it's only for short term. Don't think you can go a year with this one. This is only like 3 pages. Used to be 2. It's barely 3. It's not enough for a long-term lease. You're going to need to have like the 15-page long version if you want to do a 12-month or even a 6-month. This is just for a few days, maybe even a week at the most. Does not address typical issues in a larger lease like a security deposit. There is no security deposit in a short-term one like this. So you might want to use the official bigger one depending on how long. If it's a month, you probably need the longer version. If it's a week or less, this one will probably work. And then here's the big thing that we as brokers need to always remember to talk to them about. Hey, buyer or seller, if you're thinking about letting the other party occupy the property while you're still the owner, then let's make sure the insurance coverage is adequate. So if that seller planned on closing tomorrow and closing gets delayed until Monday, they should not cancel their insurance policy tomorrow. And if they're like my wife, they would have called a month ago and told the insurance company, hey, we're closing on the 28th of July, so go ahead and cancel the policy that day. She's going to need to call them back and say, I was being ahead of schedule. I was making sure you knew, but we've had a change. Please let the policy keep on going through the weekend. In fact, I'll just let you know when we don't need it anymore. I'll cancel it when it's ready to be canceled, when we are done with this and we're no longer the owners. So, and then if you're the buyer agent, remind your buyer, you're going to want a renter's policy. If that seller lets you move in early on Friday because your moving truck is full and you're not closing till Monday, but they're going to let you go ahead and move in, let's make sure that your belongings are covered with a renter's policy, like a little short-term renter's policy. So those are important little keys there. As a broker, you need to remind them of these things. And then also, if we need to make significant changes to this agreement, more than just filling in the blanks, the attorney's going to need to do it. And a lender should approve them. Lender might need to approve any sort of extra changes, significant extra changes made. That's a good rule of thumb in general. If the buyer's using a loan lender, the lender needs to approve things put in the contract. One thing a lender might need to approve is the personal property listed in the contract. Washer, dryer, and refrigerator included with the house, that's probably okay. That's pretty normal. But if it's also the big desk, the executive desk, the L-shaped sectional couch, the things that people don't want to pay to move because they can't fit them into their new house, and so they just dump a whole bunch of personal property in with the sale, the lender doesn't like it. The lender says, am I loaning you money to buy a house or a bunch of stuff with a house around it? And so therefore the lender might require that desk and that couch and that pool furniture to not be in the contract. So good rule of thumb, verify, make sure the lender is okay with these negotiated changes. Yeah, I can have the desk. Great. The lender might say otherwise. How do we handle it if the lender doesn't want the desk to be mentioned in the contract, but the parties still want to include the desk with the purchase? It's a $1,000 desk. It's not like a Home Depot or IKEA or something or other. It's significant, but it would need to be removed from the contract completely because the lender doesn't want to see it there. And it would need to be listed in a separate bill of sale, just handling personal property in and of itself. And the attorney would be a good place to get one of those. They have one that you can fill in the blanks usually. You're not going to want to write one up yourself, obviously, but that's one of the typical ways we handle that sort of thing. Back to this, seller possession after closing, the term, the means of access. The seller can stay in the property until 5 p.m., fill in the date, or for this many days after closing until 5 p.m. on the last day. Time is of the essence. You need to do something different with the paperwork if it's going to go beyond that date. That's what that means. Buyer shall not access during this term without seller's written permission, except in case of emergency. The seller is sold the property. It's not in their name anymore, but they have permission to basically be a renter. But that doesn't mean the buyer is allowed to just come in. Just like any landlord, you can't just come in on them. Got to give them notice. Seller will give buyer a key. It is the buyer's house after all. You do have to give them a key to their new house. They can't use it, right, without notice, but even just because the seller's there doesn't mean they don't give the keys. They do still need to give a key. And then it talks about other means of access. What other means of access besides a key? Yeah, that's my favorite one. Kirsty says code. I don't even use a key anymore, but also maybe garage door opener. That's one that everybody forgets about. And an agent has to go after the fact and go pick one up for somebody and deliver it usually because we forget to drop them off at closing or the client forgets to bring them in. Seller acknowledges a property condition and obligation to maintain. Seller says everything's in good working order except list anything that's not working. And I'll maintain it. And then here's what the rent's going to be. And it's given as a lump sum ahead of time in advance on this day of closing that we're going to start with the seller becoming a tenant. How many days are they staying? We already outlined that a couple of paragraphs ago, times how many dollars a day. And typically it's just enough to cover the buyer's new loan, but it's negotiable. But it's a lump sum given as a credit to the buyer at closing. Seller shall vacate no later than the end of the term unless they get an extension. Otherwise, buyer's entitled to seek eviction and a fee of blank dollars per day. There's a built-in penalty if the seller doesn't leave, as agreed. Who's going to take care of it? Lawn maintenance, utilities. The seller is responsible for those things like a renter would be, typically. Utilities are going to remain in the seller's name. All these things are outlined. And then once the seller leaves, they got to take the trash with them. Can you imagine? I bet it won't be a surprise that people leave stuff they don't want and think the new buyer gets to handle it. No, it's written up that you got to take your stuff with you, even the stuff you don't want. The insurance, of course, we just talked about that. Seller needs to get a renter's policy. Tell the buyer, provide the buyer with that policy if they want to have it, want to see it. And the seller policy might need to include bodily injury, property damage that the seller's liable for. And the buyer should have insurance as well. And can the seller sublease it? No, not according to this. This is short term after all. It's just accomplishing a little hiccup in the situation. Buyer's going to pay the association dues, but not the seller. And are the pets allowed or not? And then seller can be evicted. Cost of the legal proceedings that might come as a result of this. If somebody needs to be evicted, the loser pays. Usually the loser pays the legal fees. That's it. The buyer version is very similar, just geared more toward that buyer moving in early. So what should the buyer investigate during due diligence? What sorts of things constitute everything? Tell me what the buyer might need to look into to decide if they want to buy it or not. Yeah, mold. If the general inspector finds evidence of mold, sure. Survey. Any inspections could be all sorts of things. Entire house, walk through. Yeah. Encumbrances would fall. That'd be more like what the attorney might discover, because the attorney is going to do a title search. And so they would identify and reveal encumbrances that might happen. The survey helps with that, but not all the time will the survey be done. You as a broker should always recommend one. Yeah, roof issues, crawl space issues, attic, signs of any problems like meth house, if that's a concern. It's not something I've run into personally in any of mine over the 27 years, but if your buyer was particularly worried for some reason, look into maybe having whatever tests are done to find that out. Water pressure, that's important to some folks. Heating and air, whatever's important to them is a material fact. So any of those things need to get to the bottom of. How much are the HOA dues? How much are the covenants and restrictions? What are the covenants and restrictions? I mean, yeah, synthetic stucco. Did it ever have any? So the buyer can investigate whatever. And they can have anybody they want to look at it, even if they're not qualified, because the buyer can back out for any reason or no reason. Now, here's a good, easily testable question about the money. What if the buyer tries to get a loan to buy it? They can't buy it without a loan, and the loan does not get approved. Do they get their earnest money and due diligence money back if it's a day or two before closing and they find out the loan was denied? Are they entitled to any money back? If they were, it would be called a financing contingency. The contract is contingent on them getting financing. But you are all answering correctly. The natural, basic contract is written with no financing contingency. So if your loan doesn't get approved, guess what? You don't have to buy it. You can't buy it because you can't get the loan, but you're not getting your due diligence money back just because your loan didn't get approved. And maybe you're not getting your earnest money back if you didn't find out about this bad news until after the due diligence period expired. So what's a good practice for you as an agent on their behalf? Do all you can to encourage the lender to give them at least a conditional approval while we're still under the due diligence period. Or at least try to negotiate a long enough due diligence period so the lender has time to get a conditional approval, where the only thing left really is for the buyer to show up at closing. They've checked everything they needed to. Not always possible, but that's in your buyer's best interest. So now if the loan doesn't go through and they find out during due diligence period, they still have time to maybe get out of it and get their earnest money back, right? So there is no finance contingency built in. You could add one if the seller was willing to go along with it and your buyer wanted you to have an attorney or they themselves had an attorney do it. You could have one written in, an addendum that said, if the buyer can't get approved for a loan, they don't have to buy the property and they'll get their earnest money and due diligence money back. Good luck finding a seller willing to go along with that. But it's doable. It's not illegal. If, again, they're the last point, termination after the due diligence deadline, seller would keep the earnest money as liquidated damages because you're backing out for any or no reason. Just happens to be that you do have a reason you can't get financed. So who's going to be the most concerned about keys and possession being transferred before the actual closing? You let somebody move in early, for instance, buyers moving in early. What entity, company, organization, provider of services is going to care the most about who's living in the property? Let me add another little element. There we go, Deborah. How about if something goes wrong? The insurance company, right? Look out for that on the test. The insurance company needs to be involved, right? You need to let them know that the seller is no longer the owner, right? They might still be living there for 3 or 4 more days, but now they need to have their policy changed from an owner's policy to a tenant's policy. Or if the buyer's moving in early, the buyer's going to have a tenant's policy. The sellers need to maintain their insurance, right? Everybody cares. Everybody that you've mentioned needs to know about it for sure. But the point of this question is, don't forget to get the insurance coverage properly aligned for the situation. And come back from break, we'll talk about more about offer and acceptance. See you back here in 10. All right, we're back in action. Let's pick up at offers and acceptance. A lot of these, 7 and 8, chapters 7 and 8, had crossover, right? We talked about things in both that kind of crossed over. Same for 9 and 10. We've talked about some of this stuff in 9. We're just deep diving a little bit more here in 10. And so some of this stuff. The offer becomes a contract when the offeree signs, accepts the offer, and that acceptance has been communicated to the one who made it, the offeror, or their agent. Communication would be in whatever is an acceptable manner specified in the contract. What are some ways, some forms of communication that would be okay? Or that you would imagine would be okay? Yeah, sure, email. What else? Ooh, the F word. Fax, I hate. I don't miss faxes. Oh my gosh, they were the worst. Clients had fax machines and they never worked. They never had paper and I always had to drive somewhere and do something. E-signing for sure. Phone, mailing, texting. Yeah, all those things. So let's take a look at it and see how it actually fits and where it can be found in the contract. So here's our no, I think this was vacant land. I've added a lot of things. There it is. It's the second to last page of the contract, our standard form. And at the top of the page, it says this, blue box, insert at least one address or method for each party and the agent approves for the receipt of any notice contemplated by this contract. The entire page is just about how you want them to contact you. And let's look at it. First two options here. What is the buyer's information? What is the seller's information? Guess what? You don't need to know it. None of your business. Run it through me. Guess what? When I'm a buyer agent, I put withheld. They can just talk to me and I'll talk to my buyer. Thank you very much. I'm not giving you my buyer's email or my buyer's phone number, address, or fax. Now, the seller's address, probably hard to hide because it's the property we're dealing with. But contact info, this is optional. Do we want that other side to contact our seller directly? Maybe, if we're a limited service broker. Oh, there's that thing, right? Because in a limited service listing, we tell people, hey, I'm going to put you on the MLS for $1,000, but don't bother me with contract negotiations or offers. And frequently in the MLS, we'll see a little note that says, hey, agents, don't contact the listing agent on this one. It's a limited service listing. Reach out to the seller directly. And in that situation, yeah, we might have seller stuff right here. But in a full service situation, I'm probably not sharing my client's information. Because again, this page is not just, we're so conditioned as humans and brokers in general to fill in every form. And the commission wants us mostly to fill in every form, every blank. But I get this a lot. I'll sometimes get called from the other agent and they'll say, oh, looks like you left out some stuff. My office administrator wants you to add in this and this. And I'm like, if you read the top of the page, that's not what this is. This isn't, oh, please just do it because they want us to. And you got to make a choice. I've had to choose. Do I want to stand on this hill Or do I care if I give them the stuff? But officially, this is just however we want to be communicated with in the offer back and forth process, offer and acceptance. So down here on the agent portion, what's the name of the selling firm? Well, that's important. We need to put that in there. And what are you? Are you a buyer agent, a sub agent to seller, or a dual agent? Look familiar? Here's all that stuff we've been learning the last 2 weeks in the flesh. And then the firm license number. Yeah, okay. That's not really optional. We do need to admit what our license number for the firm is. Mailing address, not necessary. You're not asking them to mail notification that a signature was made and an offer was accepted to your firm, so that's not needed. This part, important. This part, optional. Because if that's not a way you want to be communicated, and it's not, you want to be emailed and called and texted. So you're probably going to do phone number and email. I'm waiting for them to take fax number off, but they probably never will, because so many times people have a fax number, but it goes to their email. So that's still a thing out there in the world. Individual selling agent, same thing. Acting as are you a dual agent? Designated dual? Check if applicable. And of course, that selling agent's license number. And the same for the other side, on the listing side. So again, this is how we tell them how we want to be contacted in the event of the back and forth during negotiations. Offer becomes a contract when the offeree accepts and communicates that acceptance in whatever manner has been dictated. So we've got that offer made. We've got the acceptance made. That's a pretty simple one. One and done. How often does that happen? Sometimes. You could have this, though. You could have an offer made, a counter offer, and then another counter, and then a counter of the counter of the counter of the counter, and finally, complete failure because they just can't come to terms. I've had them where they were $1,000 apart. And I heard phrases like, it's the principle of the thing. And I'm like, no, it's not. It's the money of the thing. Rarely is it really the principle. It's like, what if they gave you $3,000 more? Well, then I would take it. So it wasn't the principle of the thing. Or it could be this. Offer made, counter. And then finally, success, acceptance. Yay, we did it. Okay, but we're not done. We have an acceptance, sure, but at any point, the buyer could back out for any or no reason as long as they're willing to walk away from that due diligence money. What about if an offeree wants to change terms of an offer prior to acceptance? What would this create? They received an offer. They want to change something about that offer. What does this create? Good job. Making a change to an offer creates a new offer. It's a rejection of that offer. Now we have a counter offer. Yep. There you go. And we've showed this in the little back and forth diagrams last night, I believe, and last week. Communication to the agent is the same as communicating to the client. Because when we say the word agent, we're talking about buyer agent. That buyer hired you as a buyer agent or listing agent, even though the word agent officially refers to the firm. But communication to a sub-agent is not good enough. We're not under contract yet until the customer has been told that this thing was accepted and signed. Let me see. Something I just thought about. Just escaped my mind, but I'll think of it again. It's going to drive me crazy. So we have ABC Realty, this high-tech graphic over here. The buyer is the client of the agent, John. We see that word client. We know what? What is John in relation to that buyer if we see the buyer referred to by the word client? Is John a buyer agent or is John a sub-agent to seller? If we see the word, if the test question says Sally is a buyer and she's the client of John with ABC Realty, then we're going to know John is a buyer agent. Good job. Yep. It's not a mystery anymore. If it said Sally is a customer and John is helping Sally buy this house, then we know that John is a sub-agent to seller. That's his role with regard to Sally, because to him, she is his customer, not his client. See the difference? Little nuance, little hint you can look for. And on the XYZ Realty seller side, the seller is always the client of the listing agent because there is no option otherwise. You're either a listing agent or you're not, because you can't do any listing activity unless you have a signed listing agreement. So that's what's going on here. The buyer has their own buyer agent. Seller, of course, has their own listing agent. John delivers the offer on Monday at 6 p.m. The seller signs it in front of his agent at 8 p.m. Why do we say that? If the test question says something like signs it in front of the agent, that's intended to also tell you basically it's been communicated to the agent. Signing it in front of the agent is just like signing it and then calling and telling the agent you signed it. The communication happened instantly because she watched you do it. You with me on that? Watch out for that. So the signing and the communication has happened all at the same time in that very moment. And then an hour later at 9 p.m., the listing agent Mary calls the buyer agent John and says, "We have a deal." She may or may not be right. That's for you to tell me. Then John calls the buyer an hour later at 10 p.m. and tells the buyer we have a deal. And then the next morning, John, the buyer agent, delivers the contract to the buyer. So that contract didn't get into the possession of the buyer until the next day, 12 hours later or so. So at which point in this timeline did we actually go under contract? Which bullet point? 1, 2, 3, or 4, or 5? Or time. You could say time. Think about where the communication happened, from who to who. Let's look at it on here. And this might be a good thing to do on the test on your scratch paper if you really just need to see it clearly. We have a offer being sent over at 6 p.m. Seller signed the offer in front of the listing agent, and that happened at 7 p.m. Sorry, 8 p.m. And then Mary, the listing agent, called John at 9 p.m. And then John called the buyer at 10 p.m. And then the next day, on Tuesday morning, the actual contract was given from one side to the other. Nope, sorry, it was given from John to the buyer next day. We'll call it 9 a.m. next day. So for this one, the signing in front of the listing agent, is that the right communication? Is that the necessary? No, because the same side knows it. It hasn't crossed this line. This line is what counts. So it's one of these. It's not the initial offer, though, because that's not even signed offer. Is it this one? Is it the 9 p.m. one? Yeah, because we've got the listing agent telling the buyer agent, and that's enough. The buyer agent telling the buyer, not needed in order to make it under contract, because it's a buyer's agent and telling them is good enough. It's the same thing. So there it is. Third one, 9 p.m., one side over to the, there it is. 9 p.m., one side over to the other. I gave you the answer on this one, but not on purpose. Let's see. So in this one, a little prettier, we got the buyer, and this time the buyer's a customer, to John. I don't know why he's walking away from her. She's chasing him. I want to write an offer on this house. And he's like, let me read my book. I need to maybe flip him around. But he is a sub-agent to seller in this case. And the agent over here on the seller side is Mary, and the seller is her client. And John delivers the offer Monday at 6 p.m. Seller signs it in front of Mary at 8 p.m. Same thing. Mary calls John at 9 p.m. John calls the buyer at 10 p.m. Contract delivered next day. Exact same timeline, but the titles are different. And so it's because of that, because John is a sub-agent to seller instead of a buyer agent, it's not under contract till he tells his buyer. That makes sense? The mailbox rule only applies to the notification, not the money. And what it is, it says once the item is in the mail, the possession of the United States Postal Service, out of the possession of the sender, that date is good enough. The date of the postmark, essentially. And it's considered having been delivered once it's in their possession, even though it's going to probably ride a truck for 2-3 days. Good enough. That day is the date of delivery. It's when mailed, not when received. We don't do things by snail mail that much anymore, so I'm waiting for this just to be, it's basically not necessary. I'm sure there's some people that need things mailed to them, but most of it, at least in modern day real estate, is probably electronic signing / email. A lot more instant than needing all of this stuff. But this is just left over from the old days. But don't fall for a test question that talks about the due diligence money being delivered as of this date because they dropped it in the mail. That doesn't count. Due diligence money is delivered when it gets into the hands of the seller. And it may go a couple different ways. That due diligence money, how does it get to the seller? It could be that the buyer agent takes it to them and leaves it for them or hands it to them. It could be that the buyer agent meets the listing agent at McDonald's and the listing agent picks it up and then goes and takes it to the seller. It could be that the buyer agent mails it to the seller. Although I don't like that as a broker in charge, I would not let my brokers do it that way. You better not be lazy and drop something in the mail when it comes to the money. What if it's not there yet and the buyer wants to back out, or somehow it gets lost in the mail? I mean, this is people's money. I don't want my checks mailed to me. I want to get it wired in. It could be that the buyer agent gives the due diligence money to the listing agent and the seller is not, it's not an owner-occupant situation. They're in some other state and they have to mail it. Any of those things work and are allowable. So it's just going to be the choice of the parties involved. But as the brokers involved, you should really try hard to get that money, especially if you're on the listing side. Give your seller as much leverage and protection as they can get. And you do everything you can to get that money to them. Even if you got to not go to the movie with the family at the 2:00 showing, but make it the 5:00 showing, right? Get the money in hand, because if that buyer backs out and there's no money holding them to it, there's no point in the money anyway. They never had it. And that might turn into another day and another day. And eventually your seller's going to take it out on you. And they should, because it's your fault. You should have pushed. So what happens if it's been 2 days and the due diligence money is still not in the possession of the seller? What takes place at that point? Is it automatically seller just says, okay, I'm tired of this. I want my money. I'm out. I'm walking. I got another offer. Somebody just made an offer anyway, even though we were under contract, and I want to take that one immediately right now. Can they do that? Can they immediately void the current contract and take the new offer? No. They've got to give the one who didn't provide the due diligence money by the effective date, they got to give them one banking day, written notice that you didn't do what you're supposed to do. You got 1 day to make it right. And at that point, I hope you don't, because I'm just going to take this other offer. I'm mad at you now. That's probably the real world feelings the seller is going to be thinking. So that's how that could go down, right? Termination offers, we talked about a little bit. I think we had an incomplete list before. The offeree could reject it and create a counter offer. They could just reject it, and that's it. It's a rejection. The offeror could say, never mind, just kidding, anytime prior to the acceptance and communication of that acceptance, right? They can back out anytime up until the point it's been accepted. What if there is a deadline with the offer? Does that have anything to do with the one making the offer not being able to rescind? No. They can still back out. They don't have to wait until the 5 o'clock deadline that they gave the other party. The deadline is just for the other party, not for them. And speaking of deadline, the middle bullet point, if the offeree doesn't adhere to the deadline, doesn't respond and accept within that time frame, then it's automatically rejected, automatically no longer an offer, terminated. And then regardless of there being a deadline, fourth bullet point, if it's not communicated in this fancy legal term called a reasonable time frame, whatever that means, in real life, it probably means a couple days, maybe 3 or 4 days. Certainly a week would probably be beyond a reasonable amount of time to expect somebody to still consider it and not having just written it off. So the court would decide that. You'd have to hash it out. And then when it's the offer we're talking about, the either maker of it or the receiver of it, either one of them dies, it's dead too. It's not the same thing as a contract. If you make an offer and the offeree dies, the seller dies, for instance, it's not on their heirs or estate to accept or reject your offer. It's just gone, period. You got to wait until the estate and heirs inherit it and decide what they want to do, and then you could make another offer on it. But it's not anything that would still be in play. Communication to an agent is the same as communication to the what? The client. Good job. Let's talk about some addenda. We've seen a couple of them. Let's have a situation here. I'll read it out. On Monday, the sellers tell their agent that they have accepted and signed the buyer's offer. The listing agent tells the buyer's agent that they mailed the contract to the buyer's home address. The earnest money was to be delivered within 3 days of acceptance. On Tuesday, the seller changed their mind about selling the house. The paperwork has not yet arrived at the buyer's address. The earnest money has not yet arrived to the seller. The listing agent emailed the buyer's agent and told them, sellers have changed their mind. Tell the buyer to destroy the signed offer to purchase and contract when it does arrive. So which of the following is true? Can the sellers unilaterally terminate because the contract's not valid until the money is received? Can the sellers unilaterally terminate, meaning it has nothing to do with the other side letting them out? They can just choose to walk unilaterally. Terminate because each party has a 3-day right of rescission. Is that a thing? Can the sellers not unilaterally terminate because they have to give the buyer until the end of the due diligence period? Or the sellers may not unilaterally terminate because a binding sales contract exists. Good job. You got it. Yeah, it exists. Why does it exist? Because the mailbox rule. They dropped it in the mail. That was the date of acceptance. Sellers changing their mind. Why might the seller change their mind? Maybe they got another offer they liked. Not unusual. So all the more reason for a buyer and buyer agent to get their act together and get things turned in, money turned in to lock that down ASAP. There are quite a few addenda. We're just going to go over a couple of them. We've already gone over some of them. The additional provisions addendum, we looked at those 6 items. I'll recap them in a second. A backup contract addendum, we'll look at what that means in a second. A contingent sale addendum is actually not included and provided to us anymore. But when we see what that means, it doesn't mean that we can't use one. We just don't have one available. We'd have to get an attorney to write one up, custom. We used to have one that we could just fill in the blanks. FHA VA financing addendum. There's a special extra privilege to those borrowers using that type of financing that needs to be locked in, but only gets locked in if you use the paper, if you use the addendum. Lead-based paint, short sale, buyer possession, seller possession. We've seen about half of these, so let's take a look at the ones we haven't. We know that this one, I showed it to you in person, it's either for putting in a deadline. That's quite often the case back in a normal market, not a seller's market usually. You're just thankful the seller's even considering you in this kind of market. If there's tenants, it's the thing that said, look, I'm buying an investment property. I want to see all the paperwork. Have you ever had to send them a late notice? Let me see the lease. Let me get the security deposit receipts and where's that being held. If there's a septic system that needs to be installed in the property, put in, then it needs to specify how many bedrooms the house is. How many bedrooms? 4 bedrooms. Does it perk for a 3 or a 4? And specify which one is required for this to be a valid contract. This contract's contingent on the property perking for a 4-bedroom property. In other words, that'd be kind of the way you're seeing the wording on that. If the buyer wants any extra stuff, in fact, let me show it, because I think seeing it in the actual form is better. And we just looked at it, I think, last night. So there it is, the expiration. Notice that there is time is of the essence on that. It expires as of that hard date and time. The septic, bedroom perking, number of bedrooms, the rental, and then this one. Again, we're just saying that the buyer is only interested in buying this property if the seller agrees to do whatever we put in here. Quite often it's a paint allowance or actually painting it, having it painted professionally, or new carpet, maybe at the buyer's selection of which kind, or could be all kinds of stuff. Maybe the buyer's worried that the seller puts a new roof on it. And even though they know the inspector is going to write it up and acknowledge that the roof is looking pretty bad, they want to make sure the seller knows, I'm not buying it without a new roof. So that'd be a great place to put that provision. This offer requires a new roof, stuff like that. And then we know that the VIN numbers, it's a place to put those, and it's a place about who's paying to re-winterize if they need to have a pool inspection. And that's the additional provisions addendum. I don't use it that much anymore. I used to use it almost every time. In a balanced market, I would quite often put a deadline on every offer, just so the seller wouldn't try to jerk the buyer around for like a week. I'd want to give them maybe a day. If we were writing an offer tonight, I might suggest my buyer give them until like 5 tomorrow night, 6, 8. But in a market like this, again, we're just thankful that the seller's even considering us, so I don't even try it unless the client wants me to. FHA. We're going to talk in 14 and 15 about financing, and this is government-sponsored or government-related financing. Federal Housing Administration and Veterans Administration, Veterans Affairs. If it's a VA loan, the government guarantees the mortgage. We'll learn about what that means later. If it's an FHA loan, the government insures it. There is not a USDA financing addendum, if that's your question. But if there were, then obviously we would have one written or include it. But this just covers the government ones. These two of the government ones. USDA is another government one, but this is just FHA and VA. Because once the property is appraised, the appraiser goes out, and let's say the appraisal comes in low. The sale price was $300,000. It appraises for $290,000. A lot of times that appraisal, well, whatever reason the buyer might want to walk, the property doesn't appraise, they can still back out even after the due diligence period expires and get their earnest money back. It specifies that they can get their earnest money back if they back out after the end of that due diligence period. But the thing is, so basically it's, and if it doesn't appraise, they probably can't get the loan. So if the loan is turned down, they can still back out and get their earnest money back. So it's a built-in protection for that. The thing is, if you don't have this addendum included and attached to that offer to purchase, you don't give that protection to your client. So it's on your shoulders as the broker to make sure this gets, you need to think, oh, this is a VA loan or this is an FHA loan, I better include the addendum. Because they're not going to know the difference. And you don't get this built-in protection in just the standard offer to purchase. You got to attach this. Let's look at it. It's pretty simple. I think it's like one page and then one that's signed. Signature page and then the guts of it in front. Pulling it up. 1 second. Here we go. I might actually have it already. Let's see. There we go. So here it is. We just have, a guts page and a signature page. So there's the property, there's the seller and the buyer. And if it's FHA, we're going to check the top box. VA is the bottom box. And it's very easy to read. It's not easy to read. Bear with me. So it's expressly agreed the purchaser shall not be obligated to complete the purchase or incur any penalty for forfeiting the purchase of their earnest money unless they have been given a statement that says it appraises for the purchase price. So if it doesn't appraise for the full purchase price, they don't have to buy it and they don't have to lose money over it. They still lose the due diligence, but they don't lose the earnest money. They have the privilege and option of proceeding with it, though. What if it appraises for less than the sale price, but the buyer still wants to buy it? Let's look at what that looks like. Here are the options. If the property doesn't appraise, there we go. So we've got a sales price agreed upon up here. And let's say it's $300,000. And then the appraiser comes out and they can't justify the $300,000. What do? The appraiser is looking at recently sold properties similar to this one. And the appraiser can't find any justification for $300,000 on properties of this comparable size and style and type. And so they come in at $285,000. That's what it appraises for. We have a $15,000 difference. What could we do about this? Well, some options are we could go to the listing agent and say, hey, we need that seller to bring the sale price down to the appraised price. Instead of selling for $300,000, let's name it as $285,000. And after they both laugh at you, because they will, because the seller's attitude will be, well, I can't help that your appraiser did this. I'll just put it back on the market and find a buyer and get a new appraisal, and hopefully it'll be appraised for it. I'm just kind of kidding. But the seller may not be willing to come down to the $285,000, but that's an option. The seller could bring that price all the way down to there. If they won't, all we know is that the lender is only willing to loan on the lesser of the two numbers either the appraised value or the sale price, whichever's lower. And so right now, this is lower. So that's going to be the loan amount. That's going to be what they base the loan amount on, not necessarily the loan amount. But if they're borrowing 90%, it's going to be 90% of this number, not 90% of this number. And so that's our limiting factor here. The lender's only willing to loan based on this number. Therefore, and the seller won't drop their price. They're insisting on the 300. So this 15,000 is going to have to be added onto the down payment by the buyer. The buyer's going to have to add 15 more thousand into the down payment than they were planning to make up for this gap. If they can. They might not be able to afford that. That's not cheap. It's an option, though. It could be, though, that the buyer can't afford the entire 15,000 and the seller's not willing to drop it by 15, but they meet somewhere in the middle. Maybe not exactly, but let's say the seller comes down to 290 and the buyer decides that they can scrounge up another $5,000 to add on to their down payment and find their way to that point. They rewrite the contract for a price of 290. The buyer has to put 5 more thousand. The lender's happy because they're loaning based on this number. Does that make sense? So 4 choices. Seller comes down. Buyer comes all the way up. They meet in the middle, or it all falls apart and nobody buys anything and it dies. So a very real issue. And quite often in this kind of market we're in, this seller's market, I just mentioned that the seller rarely will come down. It goes even beyond that. There has been the emergence of a new document that gets added into offers these days, and it's called an appraisal waiver. And we've seen them pop up where the buyer has to sign this in order for the seller to accept their offer. The buyer has to sign something saying, look, if it appraises low, I'm not going to ask you to drop your price. I'll make it up myself. I promise in the beginning up front that I will eat it and add whatever that difference is to my down payment. I'm not going to ask you to drop your price. Why would somebody do that appraisal waiver? Because maybe if buyer offer 1 includes it and buyer offer 2 does not, they're going to go with the one who promised not to ask for the reduction. You with me? Who has to write this thing? Well, not us. It's either going to be an attorney or the client themselves, but probably it should be the attorney. But again, it says if it doesn't appraise for the full purchase price, I, the buyer, will make up the difference. I'll bring that $15,000 and add that to what I'm already putting as a down payment, bridge this gap. So the seller still gets their price. The lender still loans on this number, and that difference is handled by the buyer. Well, this thing about the appraisal coming in low is a very real possibility. And that's what this thing is talking about. Oops, let me show you this again. That's what this addendum is. If it doesn't appraise for the purchase price, then the buyer has the option to walk away and get their earnest money back, even if we're outside of the due diligence period. That's essentially what this whole thing is talking about. It's basically a financing contingency. It's adding one of those in when there isn't one built in. Same thing for a VA. Expressly agreed, buyer shall not incur any penalty by forfeiture of earnest money or be obligated to complete the purchase. Notice it just said earnest money, not due diligence. They still lose the due diligence. If the price exceeds the reasonable value of the property established by Department of Veterans Affairs. Why is there no blank on this one? Because we call it something different, as we'll learn when we get to that chapter. When it's an FHA loan, we talk about an appraised value. When it's a VA loan, it's called the certificate of reasonable value. But it's essentially, did it appraise for the purchase price or not? Oh, and by the way, if the buyer can put in that extra chunk of money, different between the purchase price and the lower appraisal, then they can choose to do so. That's what these 2 points mean. They both say this. And with a VA loan, there might be some things that that the buyer's not allowed to pay. So part of a seller accepting a VA loan is agreeing to pay some of these things that the VA won't let the buyer buy. We'll learn more about that when we get to it. I don't want to. I've told you enough about loan stuff on tonight. Yes, please. Correct. So it's your product. You bought it. You don't have to. And all we do talk about is, did it appraise? Not to say that the listing agent won't try to find out. They will sometimes call you and say, what did it appraise for? And what you'll say as a buyer agent, very condescendingly, I'm just kidding. You'll say, well, don't want me to release that info, but it did appraise for what we needed to. Was that your question, or did I interrupt? I'm sorry. Right, you got a problem to fix. And so if it appraises for less, it's in everybody's best interest to acknowledge that and figure out what we're going to do. Unless there's something you're thinking of that I'm not, as to why you might not want to tell them that it appraised for less. I guess if you're willing to walk away from the deal because it didn't appraise, they might want you to prove that it didn't appraise, right? So all the more reason to share that information with them. Were you thinking of a reason not to? Yeah, let me know if you think about it. But usually there's no reason not to if it's light, because you're trying to fix it. What could happen if it appraises less? You might be able to appeal the appraisal, but I've not seen much success with appealing to change an appraiser's mind. If it's already been established and issued, when we get to valuation, chapter 17, I think we'll learn more. It's really hard to change it in this current climate. In fact, the best method is to try to change and influence that appraiser before they do the work. That sounded really bad, didn't it? I don't mean that we're paying them $100 to talk them into putting a fraudulent number. I'm saying it is within the rights, and the real estate commission allows it, and the realtor association encourages it, that we, the listing agent, meets the appraiser at the property, and without being a jerk, says, hey, here's a list of upgrades and features you might want to use and think about when you're putting your appraisal report together. You're not there to try to bribe them. You're not there to intimidate. You specifically cannot intimidate them according to the rule and law. It says no, none of that. But you do have a shot at representing your client's best interest, your seller client, and saying, look, don't forget to give us credit for this, and this, and this, and this, because the one down the street doesn't have this fancy kitchen. This one does. And as busy as appraisers are right now, they're actually usually thankful. Unless you're a jerk about it. I've had some that were kind of standoffish because they're like, and once they saw that I was going to be cool and mellow and not like a big salesy pitch to them, they're like, gosh, the last one I went on, the agent was just obnoxious, and they kept telling me and trying to talk me into the value and being kind of rude about it. And that's not the way to do it. You show up, you change the instructions of the showing so that they can't come and look at it without you knowing, right? For one thing, so they can't slide in there without you finding out. So you have this chance. You get there, you say, I'm just here to let you in. Here, by the way, I'm just going to let you do your thing. And what they want to do is walk around outside, measure it. They got to measure it. And then they'll come inside and walk around and look at whatever they need to look at. It depends on the type of appraisal. If it's an FHA or VA appraisal, they're looking harder, right? They're needing probably to take pictures. They even have to take pictures of the running water out of the faucets when it's FHA. And if the smoke detectors work, there's a little more of an inspection kind of mentality on those types of appraisals. Once they're finished, here's my method. I'll say, I'm not going to get in your way. Okay, so here, they'll frequently come up to you and say, do you have I got a couple questions about the property. And you can say, well, great, I'm here for you, but let me give you this before I forget. And what I'm giving them is the best comps I can find. I'm not giving them the bad ones. I'll let them find them on their own. But I'm also giving them the list of features and benefits and upgrades and reasons it's worth more than anything else out there. Anything I can come up with. Some of it might be something they can't use and don't give value for, but I'm trying, right, to make sure they give full credit. I had one time, it was new construction, and my buyer it was a fixed staircase up to like a sealed weatherproof door, and you open that in, they had not finished, it was an unfinished attic, but they had put in the 2x10, 2x12 joist, so it could be finished. It had studded in walls. It had plumbing stubs, so you could add a bathroom later. It had heating capability for expansion. All of that was in mind because the first year he was in there, he wanted to turn that into 500 more square feet and had the builder build all that because it's much easier to put it in at that point in the process. Well, the appraiser came in $11,000 lower than the purchase price or contract price. And so I asked to see the report and looked at it. And one of the comps they had used was from a neighborhood nearby. And there were several comps in there, comparables, meaning comparable properties, comps that have sold like the subject property. He picked, there were two that looked like they were the exact same floor plan. And one of them sold for $10,000 more than the other. And he picked the lower one. And so when I talked to him, this was long enough ago that I could talk to him after the fact. We can't do that anymore. And so I called him very politely and I said, just curious, I see both these comps were in that neighborhood nearby, same floor plan. Why did you pick the smaller one, price point, not square footage, same square feet, but why did you pick the cheaper one? And he said, I just chose to. I'm like, okay, well, would you mind swapping them? And he said, no, I won't swap them, but because you were nice about it, I will add in the bigger one and redo my math. I'm like, you could have done that originally, but I kept that part to myself. The other thing I made sure to point out to him was, I'm just curious, how did you treat the attic space? He said, well, normally I give this dollar amount for attics. And I said, well, let me shed some light on this attic. It's actually not your normal attic. It's ready to be finished into 500 more square feet of heated living area. It's got the bigger floor joists, right? It actually has floor joists, not 2x6s, but 2x12s. That's a big difference. It's got the plumbing ready to go, the heating and air ready to go. All it needs is carpet and sheetrock. Oh, I had no idea. And I'm like, you could have asked. I mean, it was a walk upstairs to this space. It wasn't like pull down stairs. So I'm like, really? Were you just lazy that day? He came back in. He brought it up to the value because he didn't know these things. And I learned that lesson 20 years ago. And so ever since then, I've been meeting appraisers at my listings to make sure they give full credit where credit was due. And so now it has become sort of a thing that the Real Estate Commission suggests. I took a course, a pricing strategy advisor course, one of those designations you can get. And in that course, that's what they teach. Go out there. It's okay to meet them. Don't bribe them or threaten them, but give them all you can give them before the work is done, because after the work is done, we're not allowed to communicate with them. After the appraisal's published and printed, the only way we can do anything about it is to make an appeal through the lender. That's a huge difference. So if it's not done right from the beginning, you don't have much chance at all about making it right on behalf of your client. Questions? Go for it. So that's going to depend on whatever the appeal process is, because you've got a lender involved. The lender is the one that basically required the appraisal. The buyer hired or paid for it, but the lender, they don't get to pick the appraiser. They have to run it through a third-party company, because back in 2008, all the misbehavior leading up to it some of that was appraisal fraud. And so now lenders can't communicate with appraisers because they were saying, hey, appraiser, you need to make this one work. Fix this $10,000 problem or we won't use you for the next one. Obviously, that's a conflict. So that's no longer possible. That lender has to order an appraisal through a third party ordering or scheduling company. And we had to figure out how they get paid. And so the appraisers got paid less because they had to pay for that third party thing. And anyway, maybe you might have a shot at getting a second opinion, but it's just going to depend on what the lender wants and allows. And one time I had a dispute and I made the appeal, and their process was, we'll reach out to the appraiser that did it, ask them if they want to make any changes. And they did that. And he said, nope, I stand behind my work. And I'm like, turns out one of the comparables he picked was around the corner, another street, significantly bigger house, a 1-story instead of a 2-story like the subject property. That's a big problem. He never even measured my listing. He relied on my measurement because it was the first week of COVID, March of 2020. And he said, I don't want to be around here very much. He didn't even make an appointment. He did all kinds of things wrong. I still have a grudge. He's on my Facebook and I still frown when I see his name scroll through. And he didn't come up. And my seller and buyer, the buyer and seller worked something out, and the seller had to come down a good bit. But he was willing to because he wanted to buy something really bad that he had his eye on. But that was just the process was like, really? We can't just have them fight it out and have 2 appraisers and blah, blah, blah. So it depends. Your best bet is to get them right the first time. Get out there. Don't be lazy. Don't go trying to do lead generation. You stop everything and get out there in front of that appraiser and try to stand up for your seller's value. A lot of agents don't do that because they're on to the next one. Just hoping it goes well. All right. We got some more of this to cover. Probably most of the next session. We're going to finish 10 and move on into syllabus 11, which is actually textbook 14 and 15, the loan stuff, lender related stuff. That's another big chapter. When we get done with 14 and 15, then it'll be time for our midterms. So don't do that yet. There's going to be quite a bit of material we need to cover because it won't do you much good, right? You're going to have a lower score. It's going to be discouraging, and give me another couple weeks before you take that midterm. Other than that, have a wonderful weekend. Happy birthday to my wife. That's what I'm doing this weekend. And I'll see you next Wednesday. Take care.